Good morning again, everyone. This trial is in the matter of case number CFI 105/2021 and is being held by way of video conference before Justice Lord Angus Glennie, appearing from London. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by Baker McKenzie LLP DIFC. Lead counsel is Mr. Hugh Lyons. The defendants are represented by Ackingham Strauss Hauer and Field LLP Dubai. Lead counsel is Mr. Graham Lovett. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
It is from the claimant's side.
And from the defendant's side.
Yep.
Thank you. Thank you, Justice.
Yes. Right. Well, good morning. There's a housekeeping to begin with. Who wants to start with housekeeping?
Can I start with this piece of housekeeping, my lord? Which is that we had arranged for Opus to provide us with live transcription.
Yep.
You can see from my screen that Opus 2 recording has got into the link, but the messaging I'm getting on the side is that the transcriber has yet to make it in.
Right.
I wonder whether Karen McKendry can be admitted by the court, because I think that will assist everyone if we can have the transcriber in from the very beginning.
I don't know how to do that, so you have to ask.
I was addressing your lordship, but not expecting your lordship to do that. If I could be perfectly clear.
As far as I'm concerned, anyone relevant to the case can be allowed in. So
I'm looking at the meeting, the people who are present at the meeting. I cannot see anyone pending. Can you please advise them to try to join again?
Yes, we will send Ms. McKendry an email immediately. My lord, rather than wait, I've got a few bits of housekeeping, which
yes.
I'm not sure if they're from the transcript. I appear before you from the Dubai offices of my firm. The name on the computer screen is not my own, it's Miss Dumas' name. That reflects her ability with technology, which is being a lot better than mine. But Miss Dumas is here on my left, so your lordship can see her. I also have Mr. Wilkinson, who helped with the skeleton, on my right. Yes. And also with me, I have Mr. Rashad, who is going to be one of the witnesses, and also Mr. Salim Ali, who is local counsel for my clients. Mr. Lovett is assisted by Mr. Ryan Whelan and Mr. Akiki, who your lordship can see on the screen. In terms,
I can't see them. I can see that they're there, but that's it.
You can see they're there. You can't see their faces, but but you know they're there. My lord, in terms of skeletons, your lordship should have received from both sides skeleton arguments.
Yes.
I need to start with an apology that my skeleton exceeds the guideline of 25 pages.
Yeah.
As we were writing it, we realised that there was a lot of ground to cover, and we hoped that a longer skeleton would assist your lordship. And I hope it did.
It doesn't really. Longer skeletons actually get one bogged down. The shorter the skeleton, the better in some ways, because it gives you an overview of the case and tells you where you can be interested in looking. But thank you for the thinking of it. But for future reference, as far as I'm concerned, a skeleton well within the 25 pages is much to be preferred.
I hear and accept that guidance, my lord. As a matter of form, I probably need to apply for retrospective relief for having submitted that longer skeleton. Having read it, would your lordship grant that retrospective relief?
Not going to refuse that. Mr. Lovett, you don't object to that, do you?
No, my lord. No, not at all.
Very well, I'll allow that retrospectively.
My lord, the next piece of housekeeping is bundles.
Yes.
There is a extensive electronic bundle on the registry system.
Yeah.
It runs to about 2,800 pages.
Yeah.
Does your lordship have access to that?
Yes, I do. Yes. Well, I've also got a supplementary bundle, which I think only deals with this little dispute you've got about the experts.
It does, but what is anticipated is, insofar as the parties add further material throughout the trial,
Yeah.
we'll add it to the supplementary bundle rather than to the main trial bundle.
I prefer it added to the main trial bundle, because then I have all the relevant stuff in one place.
Then we will do that. The reason for not doing that, just to explain the thinking, is that the parties are struggling to access and annotate the main trial bundle on the court's website. We can see it, but we can't mark it up, and I think Mr. Lovett actually struggles to see it. And so we've been downloading the trial bundle.
Yeah, I've been doing that too. Okay, we'll add it to the supplementary bundle. Then I know it's all in the same place.
It's rather that if your lordship is marking up the main trial bundle, there's a danger that if we keep on updating it, then your lordship has to download new versions. You lose your annotation. You
lose the new documents, because I won't do that. Yeah, we'll add them to the supplementary bundle then.
Very good. That is excellent. And I should say that we've had a lot of assistance from the court's IT team on the bundle. So I should pass my thanks before your lordship to the court's IT team for that. Your lordship, in his pre-reading, may have encountered the chronology and dramatists,
yes,
which are at B207.
Yeah.
I'm not going to refer your lordship to them, but you may find that helpful as we go through, and it's at B207 and following.
Yeah, I have it printed off. Yeah.
Excellent. And the other piece of housekeeping is that we have agreed a trial timetable, as your lordship suggested, at the PTR, and that is in B213.
Yeah, I have that as well. Can I ask about that?
Of course.
You've agreed certain times for claimants' factual witnesses and then defendants' factual witnesses. Have you agreed between yourselves as to? I assume the evidence in chief will just be adopting the statement, but insofar as there may be a requirement for re-examination, does that come into it, or is these simply the times allowed for cross-examination?
At this point, we haven't discussed re-examination times, but there will have to be, just because the timetable is full, we are going to have to build a little bit of re-examination time into the existing timetable. So perhaps Mr. Lovett and I can take that offline this evening after we finish sitting.
Yes, and if we come to the end of the time for allowed for claimants' factual witnesses, for example, do we just draw stumps and say, well, sorry, no more questions, or do we adopt some flexibility?
I think the position which we've talked about in the PTR was a chess clock system rather than a guillotine system. So the idea being that in total, both sides should have the same amount of time. Yes. What I'm not suggesting is that if somebody is overrunning by 15 minutes, we should guillotine them. What they would need to do is pay the price in the next phase of their evidence.
Yes. It doesn't actually work like that, because you have, for example, 1530 today to 1800 and then 1200 to 1330, all just marked as claimants' factual witnesses.
We do, but I mean, imagine that the claimants' factual witnesses ran past 12:30 by 15 minutes. I think what I had envisaged is that I would then, I think Mr. Lovett, who's cross-examining, would be trespassing on my time, but I would effectively be making a note that he's trespassing on my time and say, well, actually, you have to give up some time later on in the trial to make up.
There will be no more time for him to give up, because all he'd be doing with his witnesses would be, you mean he'd give up re-examination?
He'd have to give up re-examination, or he'd have to give up some time on the experts on Thursday, for instance.
Okay. Well, I assume it won't come to that, because I'm sure you'll cooperate, but that's just sort of marker of the problems that can happen.
Yes, I'm conscious of that, and I'm conscious that we will all need to keep a close eye on the clock.
Can I raise one question of housekeeping which concerns today? I have to take a call sometime after 11. I'm not sure exactly when, because they can't tell me. But I may have to interrupt the progress of the hearing, and any time lost that way can come out of the lunch break, maybe, if that's all right.
Yes, and that's it. That's 11 London time, so 2 o'clock Dubai time.
Yes.
Yes. So
which would be in the middle of the defendant's oral opening,
yes.
by the look of it. But we then shift around. We won't lose any time overall.
Can I just pass that to Mr. Lovett, because it impacts him? But I hear your lordship, and I'm sure we can work around it.
Is that all right with you, Mr. Lovett?
Yes, indeed, my lord. You will probably need a break anyway. I'm sure.
Yeah, well, I'm afraid I can't tell you any more precisely what the time it'll be. My wife will just come and tell me I'm needed. So
That's fine, my lord. It will not impact our opening. So please just do go ahead.
the other thing I wanted to raise was, I think someone has raised a question about which order final speeches, closing submissions should go. Do between you have a preference? I've forgotten what the normal rule in DIFC is, but usually I think in Scotland, where I've been a judge, you have the claimant going first and then the defendant. Does anyone have any views on that?
Your lordship will be firstly pleased to know that DIFC follows Scotland, so that the normal rule is the claimant goes first, the defendant second. I had floated the idea of adopting the reverse position, which is the position adopted by the Commercial Court in London, principally because, as we talked about at the PTR, most of the running is being made by Mr. Lovett's team on the breaches. But I rather think we can perhaps come to this on Thursday evening, if
just if you're preparing, you might want to know beforehand.
Yes, I mean, I suspect what we say will pretty much not change, but I'm sympathetic to that.
Yeah, well, we'll revisit that. Okay, what else is needed by way of housekeeping?
So the next point is this: is that the good news is the transcribers have been admitted. I'm being told that in order to make the live transcription work, Opus need permission to record the hearing, and therefore I would ask your lordship for permission for Opus to record the hearing.
Yes, who's the case progression officer today? Is that?
We had Saeed on earlier, my lord.
Saeed, are you there?
Yes, Judge. Just 1 second, please. I'm just checking with the registry.
Yeah.
1 second, please.
It's not working.
No.
Do you want mine?
They're sending me another one today.
Do
I
you
don't
want
need
mine
it. I'm
today?
just no, it's fine. I'm on here because I haven't got Magnum, so it's
Oh, okay.
Can I just interrupt and say that the transcribers can be heard? So can I just encourage you to mute yourselves?
I'm just waiting for Saeed to tell me what the form is, because I wouldn't want to make an order which is contrary to DISC policy.
Well,
as per the protocol, the recording has to be done from our side. That's the normal procedure here on our side. That's why I'm checking right now with the registry if we can check if there are any exceptions.
I think it would be helpful if we could make an exception, because if they're going to have a live transcript, if that's been agreed as a sensible way forward, I think it needs to be recorded by Opus 2.
Right, of course, I understand that. Let me just double check with the assistant registrar and I'll come back to you in a minute.
Yeah.
Perhaps what I could ask is that Opus 2 just drop me and Mr. Lovett and our teams a short email explaining why the recording needs to be made. I think they flagged this issue with us at the PTR, but I should be perhaps helpful to have that reminder as to why we need to record the evidence.
If they could do that, we can move on to other topics.
Exactly that. My lord, the next topic is the exciting topic of witnesses. As your lordship will have seen, you're hearing from 4 factual witnesses and 4 expert witnesses. Many of those will be giving evidence from overseas. At the PTR, your lordship asked that we confirm with the registry that each of the jurisdictions from which a witness is giving evidence has no difficulty with the witness giving evidence to the DIFC court. Mr. Lovett and I have spoken to respective local council in the different jurisdictions, and that confirmation has been provided to the registry. So
that's helpful.
Um,
I'm assuming Mr. Lovett will come in if he disagrees with anything at the moment.
Indeed, my lord. I'm happily sitting quietly for the time being, but I agree with that.
Yeah, thank you.
I had no hesitation that Mr. Lovett would correct me if I was wrong.
Yeah.
The next topic I have on my list is the position paper.
Yes.
Your lordship will recall that at the PTR you directed that a position paper be served.
Yes.
Mr. Lovett's team did that. It's in the bundles and it's referred to in their skeleton, and your lordship may have looked at it.
Yeah.
We are concerned that it introduces a further 6 warranties which were not previously relied upon, and that it also makes reference to 3 further pre-completion covenants, which again were not previously relied upon.
All right.
Our position is that your lordship is not in a position to make determinations in relation to those alleged breaches, because the issues of Kuwaiti law which are raised have not been canvassed by the witnesses. The factual inquiries which might be necessary to deal with those breaches have not been canvassed, and the quantum issues which arise have not been canvassed by the experts.
Before you go any further, can you tell me? I have printed out the position paper. I note that at page 4, page 116 rather, they say in paragraph 6 that the defendants are not advancing any new claims for breach of warranty in this position paper. Now, is there a dispute between you on that?
The factual material relied upon remains the same. The relevant clause in the SPA, which is said to have been breached, has changed, or at least has expanded.
Right. Are you going to identify which ones you're talking about, or you can hand it in a piece of paper if you like, data? But
well, I mean, it may assist your lordship if you have that position paper to hand.
Yes, I do. Yes.
The 3 warranties which had previously been relied upon, and there were only 3 previously relied upon, are the first warranty relied upon on page 2 of the position paper, which is the Schedule 5, Part A, Fundamental Warranties, Clause 2.6. That had previously been relied upon.
Yeah.
The next one down, 3.1,
yeah,
was not relied upon previously. At the top of page 3, there are 2 warranties, Part B, 3A and 3B. They again are new.
Yeah.
The next one down, which is Schedule 5, Part B, 1.1, that has been relied upon throughout. That is in the RFI.
Yeah.
The next one down, Schedule 5, Part B, 9.1, that also has been in play throughout.
Yeah.
And the next one, 12.8, that is new. That had not been relied upon before the before this document was served. And likewise, the last 2, 18.2 and 18.3, are new.
Right.
In addition to those warranties, you also find in the position paper reference to various trying to find an example of one when I speak. There is reference to various pre-completion covenants, and perhaps your lordship can see that best on page 6 of the of this position paper. Towards the,
yes,
and you can see that there is reference to subclause 4.3c.
yeah,
There are 3 such clauses relied upon. Each of those are new into the position paper, and which were not previously relied upon in the response to requests for further information. I'm not clear what cases advanced on that, on these 3 pre-completion.
so I've only got 2.
There's 2 there, and there's a 3rd one later on in the document.
I see.
But it's not clear what cases advanced, because they make no appearance in my learned friend's skeleton argument for the trial. So I'm not quite sure whether these are here by way of decoration or whether they're here by way of a substantive right.
Right.
My lord, I raise the point because we are concerned that your lordship is ill-equipped to make determination on this extensive repleading of their case. Your lordship,
is your point a formal one, that is not part of the pleadings and it shouldn't be part of the argument?
It's not. Well, there are a number of points. There's a formal point, but there's also an evidential point. The first point is that it's not part of the pleadings, and of course the case therefore has not been prepared on that basis.
Yeah.
There is no factual evidence addressing these particular lines of attack, and there is particularly no expert evidence addressing the particular line of attack. The Q80 law experts have not addressed these particular provisions, and insofar as those quantum issues are again not addressed. The good news for your lordship is that I'm putting down a marker at this stage, because the 17 heads of claim, which my learned friend identifies in the position paper, each of those has an existing warranty underlying it. So I'm not suggesting at this early stage your lordship needs to make a decision as to whether to allow these additional breaches to proceed. But what I am doing is I'm putting down a marker that when it comes to closing, we should say you can't advance a case based on these new provisions. And so just to give that some reality, as it were, if I take your lordship to page 8 of the position entitled Revenue from Canteen Services at ICS.
Yes.
In the bottom left-hand corner, you can see that the warranty relied upon is clause 1.1. That was a warranty which existed in the response to the request for further information, which was served in November of 2022, and on which the case has been advanced. So we will say that obviously can proceed. But the second of those warranties is new to us. And so the factual material, insofar as it relates to the first warranty, will need to be heard. The question is can the legal consequences, which may follow from the additional clause, be properly argued? And that's how I'm happy to address your lordship on in closing, but I should fairly raise this point now that we have serious concerns about them.
Sorry, just so I can get my head around this, will it affect the cross-examination and the evidence in chief? Witnesses may be asked about these matters in connection with what you say is a new warranty asserted. Am I meant to be ruling at that stage that they can't be asked those questions?
Well, I have had no notification from Mr. Lovett that he intends to advance new evidence in chief to support these allegations, either in chief from his factual witnesses or in chief. But if that were to come, I would object to that, my lord.
And similarly with cross-examination.
Well, on cross-examination, I do not intend to cross.
Mr.
Mr. Lovett
Robert's
Yes.
cross-examination.
I do not know what my learned friend proposes to do, and perhaps it's time to pass the baton to him to see what he has to say.
Mr. Lovett, do you accept that the ones identified are in fact have not in fact previously been relied on?
Short point is, my lord, no, I don't. There are, I think, four, and I've addressed this quite extensively in my oral opening, so perhaps the best thing to do is to deal with it there. But in summary, there are four new claims. I think Mr. Lyon said there's no new factual evidence that's been advanced. It's just four new warranties or warranty claims are being made on the back of existing facts. There are no new facts in the case. The first one arose as a consequence of Mr. K.O.'s Matthews, I think it's his third witness statement, which was responsive to a witness statement that was served by my friend on the evening of the PTR, but was not mentioned at the PTR that this was coming. But that was a factual issue that's been raised in consequence of a late witness statement that was served on the day of the PTR. So that's one of the warranty claims. The others are a consequence of Ms. Record's expert witness evidence, her testimony, and I believe it's her first expert evidence where these matters are raised, and she identified potential warranty claims arising out of issues that she was asked to review. So that's the origin of what my friend has called new warranty claims. But from my side, these are all based on existing matters of fact, which are and have been between the parties almost since day one. And so we say there is absolutely no prejudice whatsoever. But my friend has laid down a marker. I'm happy for him to address you on it later in the trial, but I will be covering these issues in my oral submissions as well.
Well, should we then leave it on that basis that markers laid down, marker acknowledged, and we'll see where we get to. On the same topic, though, a related topic, one of the points I picked up from the opening submissions was that the defendants were relying on issues which had not been raised within the year, the holdback period. I'm not sure whether that is an objection to these points, because I looked in the pleadings and I couldn't find any point being taken to that effect. Mr. Lyons, are you able to help on that?
Your Lordship is right that there are no points in the pleading. And that, of course, arises because of the history of the pleading. The particulars and the reply was served before the response to the RFI was served. And that response to the RFI was served in November of 2020. And it's that document, the response to the RFI, which sets out the cases, the various breaches which are relied upon. Perhaps I should show your Lordship that document so that we have it. When we are dealing with the witnesses, it's proposed that one of our respective teams will present the documents on the screen so the witness has them. Does your Lordship want me to present while I'm addressing your Lordship, or would you prefer just to look at the documents on your own screen?
I can look at my own screen.
Very good, my Lord. Can I take your Lordship to bundle A, page 103?
Yeah, I have it.
And you can turn the page, and it's there that your Lordship sees the various different heads of claim which are relied upon.
Yeah.
And you can also see the warranties which are relied upon, and that there are only 3 which are relied upon. But it's only at this point in November that we learn what is new. And there are 2 claims advanced in this response to the RFI which had not been traversed in the correspondence exchanged in 2020.
Yeah.
And first amongst them is the claim in relation to fire licences.
What number is that?
I thought your lordship was asking that question, and that requires me to find it promptly. Oh, sorry, 17B at the top of page 109. Non-compliant. That had not made an appearance until this document, and equally the reference to marketing costs had not made an appearance before.
Which number is that?
Marketing staff costs, and that, and I'm sorry, the sequencing is not. 12A.
12B.
12A at the top of 108, the preceding page.
So 17B, 12A, and any others?
There were some which had been advanced, which related to a letter sent in after the 1 year period, but those claims have been dropped. So I think for present purposes, the only two which are currently live are 12A and 17B.
Right, and what's your position on those? Is it that they're not allowed to raise them, or that point is not insisted on?
I am going to advance that case, but I mean, I'm perfectly happy for your lordship to hear the evidence and to make a ruling on that. It seems to me that's the prudent course.
Very well. Yeah. Okay, thank you. That's helpful. Is there anything else you want to raise by way of housekeeping?
Only this, my lord, which is that your lordship may have seen a tussle between my learned friend and I about the Q80 experts. There are two issues. One is that the Q80 law experts have yet to finalise their joint report. We had a helpful email from Mr. Lovett's team in the small hours of the morning telling us that their expert had been very busy, but was now going to make contact with our expert and try and progress that joint report. As of this morning, our expert had not heard from Mr. Lovett's expert. I wonder whether your lordship could give some judicial encouragement for that joint report to be finalised and submitted by sometime on Wednesday.
Mr. Lovett, you happy for some judicial encouragement?
I'm very happy for you to give that, my lord. Yes, it may help focus our expert on what he really does need to do.
Right. Well, if you can take it that I would encourage the experts to try and reach agreement and to lodge to file in the process any joint report they're able to reach by when, midday Wednesday, Dubai time.
I wonder. Yeah. So that should we try for that, my lord? And if there needs to be another couple of hours, then we can ask on behalf of the experts for that. But midday on Wednesday would make a lot of sense.
Very well, thank you.
The second point is this, which is that there has been a tussle in relation to the drafts of the joint report that have been exchanged to date. Mr. Lovett has served a witness statement from one of his associates, Mr. K.S.C.P.
Yes.
What that witness statement seeks to do is to go into the drafts of the witness or drafts of the joint report and to go into the joint meeting. As your lordship knows, those joint meetings and those drafts of the joint report are normally protected from discussion before the court. I'm not going to press for that rule to be adhered to if your lordship and Mr. Lovett think it would be helpful to examine this material.
If I can tell you my initial view, subject to any argument, was this, that normally those discussions are confidential, but where it is alleged, as I think it is here, that the problems in reaching a joint agreed position have in part been caused by the lawyers acting, or representatives of the parties acting for one party or the other. That goes to the credibility of the witness and is something that is not covered by privilege. But that's a very initial view, and I'm willing to be persuaded out of it if necessary.
My lord, as you'll have perhaps seen the correspondence, we are from our side perfectly content that there has been no improper interference with the experts, and that what has been exchanged between the experts is a reflection of the experts' views, albeit we do accept that in one case the language used was ghosted by a member of this firm, but we say that language was adopted and passed on by record. But we are not going to stand on our rights. If your lordship thinks it would be helpful for there to be cross-examination on this point, we think the sunlight is the best disinfectant, so we are content for that to happen.
Well, whether it's helpful or not, I'm not going to stop it. So yes. If that is a line to be pursued, so be it.
Very good. Those were all I had by way of introductory remarks.
Mr. Lovett, did you have anything else you wanted to raise at this housekeeping stage?
No, my lord. I am content at this stage to proceed to openings.
Very well. We've already eaten in 10 minutes of your opening, so if we, Mr. Lyons, if you go to maybe 13:35, that would split the 10 minutes we've wasted. We've taken up.
My lord, very happy to do that. Just before I do that, various messages have popped up on my screen about the permission to record. Can I just pause and check where we are? Your lordship may have been paying attention to those messages.
Yeah, you check.
There seems to be a slight lack of clarity on my team's side, and I just wonder whether it'd be helpful for the registry to confirm whether there is permission to record.
Now,
My lord, looking at the time, 12:52. I will do my best to make up some time if I may.
Yes, very well. We'll take your oral opening. I presume that opposite to Karen is now set up.
Karen, can you confirm that you're...
Yes, I'm live and we're good to go. Thank you very much for your assistance.
Thank you. Right, yes, Mr. Lyons.
My lord has had the benefit of very full written openings from this side. Your lordship will be pleased to know that I don't intend to repeat what was said in those written openings. What I was proposing to do is simply to give your lordship the briefest of outlines of our case, and then to look at some of the documents that will be raised at the trial. As your lordship will know from his pre-reading, the claimants are an Kuwaiti-based education company, and that school's ultimate beneficial owner at the time of the transaction. The broader group owned by Mr. Algeri ran 20 private schools in Kuwait and was the largest single provider of private education in Kuwait. The claimants sold their 100% shareholding in Dar Al Salam Education Company. That is a Kuwaiti company and will be known throughout the case as the company, or DAS. DAS operated 2 established schools in Kuwait, the Indian Central School, known as ICS, and the Pakistani English School, known as PES. In addition to those 2 operating schools, DAS had also almost completed the construction of 2 brand new schools and had begun to speak to the Ministry of Education about licensing those schools. Therefore, what was sold was 2 existing businesses and 2 nascent businesses. The defendants are the purchaser of the shares in DAS. The first defendant is a Kuwaiti investment house. At the time of the transaction, it was known as AMAN Investment Company K.S.C.P. It has recently changed its name to the Securities House.
Yeah.
Nothing turns on that. It's just that as your lordship looks at the documents, your lordship will just need to bear that in mind. The second defendant is a Kuwaiti company. It is 60% held by the wife of Mr. K.O. Matthew, who, as your lordship will hear, was a key player in the transaction. At the time of the transaction, the second defendant was known as Al Ameri Education Company WLL. The third defendant is a Kuwaiti company owned by the first and second defendants. As your lordship will have picked up, the sale and purchase of the shares in DAS was effected through a sale and purchase agreement dated 15 May 2019. Part of the consideration payable under that SPA was deferred for 1 year after completion. Completion was on the 26th of June 2019, and that deferred consideration, known as the holdback amount, became payable on the 26th of June 2020. The claimants seek payment of the holdback amount in the amount of Kuwaiti dinar.
You're going mute at times.
That is rather scary, but let me see what we can do. If your lordship continues not to hear me, can your lordship let me know?
Yeah.
The claimants seek payment of the holdback amount in the amount of 4.5 million Kuwaiti dinar.
Yeah.
That is north of 15 million US dollars. They also seek payment of 447,872 Kuwaiti dinar, which the claimants paid by way of advanced salaries in respect of the period of time when the defendants had taken ownership of the company. In other words, the claimants paid dues which would otherwise have been paid by the defendants. Finally, the claimants seek reimbursement of the costs that they have incurred in maintaining letters of guarantee with the Kuwaiti Ministry of Education. In response, and as your lordship will have seen, the defendants say that the claimants are in breach of certain warranties under the SPA, and that they now say that they are able to set off Kuwaiti dinar 2,265,383 from the holdback amount. As your lordship will have spotted, the claims now advanced by the defendants are not sufficient to wipe out the full holdback amount. Indeed, the defendants recognise that the sum of 2,265,383 293 Q80 dinar is payable to the claimants. Despite recognising that amount being payable, the defendants have not paid that amount to the claimants. They raise in their skeleton at paragraph 44 two reasons for not having done so. It will be the claimant's case that those reasons are at best spurious, and that despite the admissions made on their behalf, the defendants continue to refuse to pay the sums which are properly due to the claimants. In relation to the other two claims, the defendants deny the claim for payment of advanced salaries. They admit liability for the sums due under the letter of guarantee, but they quibble about the quantum of that claim.
Can I just interrupt you for a second, Mr. Lyons?
Yes.
I meant to ask this much earlier. Will I be getting a copy of whatever transcript is emerging?
That is the idea, my lord.
You'll get your live transcript on screen, are you?
I am. Does your lordship want the live link? Because you should be able to have it if you wanted it.
If it's possible, it'd be quite useful, particularly during the evidence.
Let me do this. It may be that we've asked the wrong questions of Opus. Let me make sure that one of my team could just have a conversation with Opus, and we will try and get your lordship a link.
Yeah, there's no rush for it. During the opening,
Okay.
I don't need it. Yeah.
But the idea will be you will get a finalised end of day transcript, and we had hoped that your lordship would have the screen with the language in front of it.
Thank you. Right, sorry to interrupt. Yeah.
That was all I was intended to say by way of introduction. I was now going to show your lordship some of the documents, and
Yes.
your lordship may have dipped into them already. But may I start with the SPA, which your lordship finds at
I have a
page-
printout. I have
Great.
a printout.
Excellent. Does your lordship on his printout have the trial bundle numbers, or do you want me to use the original page numbers?
I've got the trial bundle numbers.
That is very helpful indeed. Can I start at page A18? And can I show you on that page the date of the SPA, which is at the top left-hand side, 15th of May 2019?
Yep.
And can I show you the parties? I've already introduced the parties, but you see them there with their original names.
Yep.
And you will see, unsurprisingly, that the first three parties are described as the capital B buyers, and AJIAL and Mr. Algeri are described as the sellers.
Yep.
Turning the page to A19, we get into the interpretation section. Your lordship, insofar as he hasn't already done so, may wish to highlight the following. The definition of accounts, and your lordship will see that those are accounts prepared in accordance with IFRS. And in the last two lines, the accounts are for each of the three consecutive accounting reference periods, the last of which ended on the accounts date. And so below that, you see the accounts date as 31 August 2018. So it follows from that that the accounts are those ending 31 August 2018, 31 August 2017, and 31 August 2016.
Yeah.
Your lordship then sees a definition of affiliates, which I don't think is particularly remarkable, but it may rear its head.
Yeah.
Skipping to page A21.
Yeah.
Your lordship sees a definition of the company means Dar Al Salam Education Company WLL, a limited liability incorporated and registered in Kuwait.
Mm-hmm.
Your lordship then sees two below the completion date. That is referred to by reference to clause 7.2. 7.2 doesn't much assist your lordship, but I think it's agreed between the parties that the completion date was the 26th of June, 2019.
Yep.
And lastly, on that page, I direct you to the disclosure letter.
Yep.
And we'll see the function of the disclosure letter in due course. On page A22, I direct your lordship to the definition of existing schools.
Mm-hmm.
Slightly unhelpfully, the names used in the SPA do not quite accord with the names used in practice, but your lordship sees that they are the Indian Central Private School, which is known as the Indian Central School, and also the private English Pakistani School, which is known as the Pakistani English School, respectively ICS and PES. Your lordship then further down sees the definition of holdback amount, the reference to clause 6.2d, and your lordship then sees IFRS defined, that of course being a term we saw when looking at the accounts definition.
Yep.
Turning the page to A23, your lordship sees a definition of losses. And the reason I flagged that is that will be picked up when we look at the what may be set off against the holdback amount. And your lordship also sees a definition of material adverse event. Whether that definition will assist your lordship remains to be seen, but I draw that to your attention anyway.
Mm-hmm.
Turning the page to A24, your lordship sees the purchase price defined as 18 million. And your lordship also sees reference date accounts. And that means the pro forma balance sheet of the business, together with supporting balance sheets, signed off by management and dated 31 March 2019.
Mm-hmm.
At A25, your lordship sees the definition of two new schools, means that two new school buildings owned by the company currently pending licensure and described in clause 17.2 and located at that address. And your lordship will have seen from his pre-reading perhaps that actually what we have is a very large site with the Indian Central School, the Pakistani English School, and these two new schools all on the same site. They are all neighbours of each other. Lastly, on A25, your lordship will see the definition of working capital amount. And that definition may come into play in relation, what will come into play in relation to the claim for the advanced salaries.
Yeah.
On page A26, clause 2.1 sets out the sale. The sellers shall sell and each of the buyers shall buy or shall purchase those parts opposite each such seller's name in Part A of Schedule 1. And I'll show your lordship Schedule 1 in due course. But that's the operative sale and purchase provision. At the risk of being too quick, I think I can jump your lordship to A29. You'll see at A29 the heading pre-completion covenants. And I identified in my opening remarks that the position paper now identifies 3 pre-completion covenants. Let me show you what those are. I genuinely don't know what case my learned friend advances on those, but let me show you them for good measure. The first is 4.1F, which is 2/3 of the way down that page. Any authorizations, permits, contracts of any kind. Sorry, I should start with the operative language. AJIAL for itself and on behalf of Talal shall procure that between the date of this agreement and completion, and shall keep the others informed that any authorization, permits, contracts, etc., will be transferred to the name of the company. Jumping forward to A31, 4.3C, AJIAL for itself and on behalf of Talal shall notify the buyers of any materially adverse event having occurred in respect to the company's relationships with its customers, auditors, suppliers, insurers, bankers, or any other party with which the company has a business relationship. I pause to point out that materially adverse event is not capitalised and that is in contradistinction to little b above.
Yes, I see.
And then I take your lordship to A32. I'm sorry, I don't take away A. At A31, your lordship needs to read 4.5 without prejudice to the generality of clause 4.4 and subject to any applicable law as from the date of this agreement. The AJIAL for itself and on behalf of Talal shall procure that, and then the covenant you need to look at is on page 32. It's 4.5D. The buyer is provided with any updates to be delivered at least 3 business days prior to completion. Such updates shall detail. And I think the one which is being relied upon is Roman 6. Any event or circumstance that may be of more than insignificant importance for the business's operating results, assets, liabilities, future prospects, or market condition, market position. Sorry. On A34, you see clause 6 entitled consideration. Your lordship has already encountered the definition of purchase price, which was 18 million. And from that, you take off the leakage adjustment. I think it's common ground between me and Mr. Lovett that your lordship doesn't need to trouble himself about the leakage adjustment.
So where's the leakage adjustment?
It's a definition, my lord. So I was reading 6.1. And 6.1, which is the consideration, is made up of the purchase price, leakage adjustment. And if it was of interest to your lordship, the leakage adjustment is defined. Well, a leakage is defined at the bottom of 22, and leakage adjustment amount is defined at the top of 23. But they're not definitions I think we need to trouble ourselves with.
Right.
What your lordship will see, though, is in 6.2, this is how the 18 million consideration is split.
Yeah.
There are various stages. And I should show your lordship over the page, at page A35, little d, just an inch below the top of the page, 4,500,000 Q80 dinar, payable 1 year after the completion date, the holdback amount. And that is the amount which is disputed in this case.
Yeah.
Paragraph 8.1 on page 36. This is the giving of the warranties, and we'll see the warranties in due course. AJIAL for itself and on behalf of Talal represents and warrants to the buyers that each of the warranties is accurate in all respects and not misleading at the date of this agreement.
Mm-hmm.
And your lordship will remember that the definition of warranties referred us to Schedule 5, which we will come to look at. And the other point I should make is the warranties operate twice, both at the date of signing, but they're also repeated on the completion date.
Mm-hmm.
At A38, see a clause entitled Seller's Obligation to Reimburse.
Yeah.
Right to reduce from holdback. 10.1 is the obligation to reimburse for losses, but only losses which arise in certain circumstances. And so I'm going to direct your lordship to 10.1a.
Yeah.
Any losses to the buyers or the company arising out of any breach of warranty. And then B is the leakage adjustment, and C relates to pupil numbers. Again, I think it's common ground between us that only 10.1a is engaged. And the point that I make is that 10.1a refers to losses arising out of any breach of warranty. Your lordship saw that a warranty was defined by reference to Schedule 5. It does not include, we will be saying, the pre-completion covenants, which your lordship...
Pre-completion what?
Pre-completion covenants,
yeah,
which your lordship was looking at in clause 4.
Yeah.
And then 10.1 is the right to seek reimbursement. 10.2 is the right to set off against the holdback amount insofar as the losses have not been cured.
Yeah.
In the event sellers are able to cure any such losses, buyers have the right to deduct any and all amounts from the holdback amount owed to the sellers with respect to any losses referenced in subclause 10.1 above. We say that the consequence of that language is it's not all and every losses, it's only the losses caught by 10.1, and that is the losses which arise from a breach of capital W warranty.
Mm-hmm.
I labour that point, my lord, because it seeks to render nugatory the reliance, if there is reliance, on the pre-completion covenants. There is a specific remedy in relation to clause 11.9, and specifically with respect to fulfilment of the sellers of clause 11.9, the buyer shall have the right to delay payment of the holdback amount. So if there's a breach of 11.9, there's a right to delay payment of the holdback amount. The good news for your lordship is that 11.9 does not apply on this case.
Yeah.
Turning through at at A45 of the bundle, clause 24.
Mm-hmm.
Your lordship sees what I think he already knows, which is in 24 spot 1, that the disputes are subject to the exclusive jurisdiction of the courts of the DIFC. So the good news for your lordship is that we're all in the right place. And 24 spot 2 makes clear that this should be governed by and construed in accordance with the laws of Kuwait.
Yeah.
At A47, this is Schedule 1, which your lordship saw referred to in 2.1, which was the key provision dealing with the sale. Schedule 1 is in 2 parts. Part A tells you who owned the shares before the sale, and Part B tells you to whom the shares were transferred.
Yes.
In short, AJIAL owned 99 of the shares, and Mr. Algieri owned 1 of the shares.
Yeah.
And they're transferred 98.
Does anything turn on this?
Not a great deal. Only that, in fact, it doesn't quite happen as the agreement. But that's all you need to know.
Yeah.
I think. I don't think much turns on it. We can now travel more quickly and look at page 55, which is the warranties page. In Part A, you can see fundamental warranties. The warranties which arise in this case are as follows. On page 56, clause 2.6, except to the extent disclosed in the disclosure letter, the company is in full compliance with all relevant tax, social security, labour, safety, environmental, statutory and administrative regulations in all jurisdictions. And the emphasis I place there is on the word regulations. The second provision which appears, and this is one of the new provisions which has been introduced in the position paper, is 3.1 under the heading related party transactions. All details of any goods and services, including without limitation, management and other head office services supplied by any seller or any other person connected with any seller of the company, or supplied by the company to any seller or any affiliate up to the date of this agreement, are set out in the disclosure letter. The details include the name of the relevant person connected with such seller and the nature and amount of the supplies and the term of supply. As I say, this is newly introduced in the position paper. We make 2 points about this clause. There has been no evidence from the Kuwaiti law experts as to how this clause should be interpreted. And in particular, there is no guidance as to how the Q80 courts would consider the requirement to disclose any goods and services. In particular, would goods and services provided for no cost be caught by this clause, or would the Q80 court understand this provision simply to relate to goods and services that incur costs? Your Lordship has no expert evidence on that point. And it's going to be our case that when you read this clause with clause 3.2 and 3.3, the focus is on a commercial relationship for which money may exchange hands, rather than anything which is done gratuitously. The second point to make about 3.1 is that the promise is one to make a disclosure. It is a disclosure obligation. And no evidence has been led as to what is the consequence of the breach of such a disclosure obligation. We say that it does not follow that the breach of a disclosure obligation is the same as a breach of a positive obligation. And I can develop that in closing, but that is what your Lordship is missing.
Just on that general point, am I restricted by the experts on what Kuwaiti law is on a point, or do I take the guiding principles as established in Kuwaiti law and then use my own judgment to apply them as appropriate?
Well, we say your Lordship is in real danger if he takes that second path, particularly where the parties have been denied the opportunity to tell your Lordship that the path which he might instinctively wish to follow is not the right one as a matter of Q80 law. Yeah. So we would caution against thinking that the court can patch over an evidential hole at this point. It may be that that is the right course, where the experts have had the opportunity to give this proper thought and have remained silent. At that point, the court may think that it may patch the hole. But where there has been no opportunity for the experts to consider the issues, we would caution against trying to go too far.
Okay.
Page 57. Reliance is placed on the accounts warranty. This is one of 3 warranties relied on in the response to the RFI. You'll see that this has 3 parts. And Your Honour may have picked up that there is a debate as to whether IFRS requires the disclosure of any services provided without charge from a parent company to a subsidiary.
Mm-hmm.
The claimant's experts say that where services are provided gratuitously, there is no such obligation to record them in the accounts under IFRS. The defendant's expert recognises that there is no express provision in IRFS to disclose such information, but says that that disclosure obligation arises from the broad conceptual framework underpinning the relevant accounting standard. But in any event, and as your Lordship will have seen, our principal case is that, in fact, the parent, AJIAL, provided no such services to DAS. So our principal case is no such services provided by parent to subsidiary from AJIAL to DAS. But even if they were provided, and they were provided gratuitously, that is not a breach of this warranty.
Yep.
At page 58, reliance is now placed on 3A and 3B. These were not included before the position paper had been served. That is a material adverse change warranty at 3A. Your lordship will know that the English courts have considered material adverse change in a number of cases over the last decade. Because of the lateness that this provision was introduced, the Kuwaiti law experts were not asked to consider whether this provision had been looked at by the Kuwaiti courts or how it works. Your lordship has no guidance from the Kuwaiti law experts as to how a material adverse change provision is interpreted by the Kuwaiti courts, whether it's a two-stage test, and where the threshold might perhaps be as to materiality. The danger which arises from the late introduction of this provision is that your lordship is literally going to have to shoot in the dark as to what Kuwaiti law might be.
Yes, you mentioned English case law. You mustn't assume that I'm up to speed on that. So if anyone wants to direct me to it, they'd better do so.
Well, my lord, I have the benefit, if that's the right word, of being assisted by Mr. Wilkinson, who is New Zealand qualified, and Ms. Dumar, who is South African qualified. So I'm often told that I should not assume that English law is fully understood. So, well, insofar as we need your lordship to look at them, we will direct you to those cases in closing.
That's fine.
In 3B, there's a promise that the business has been carried on in the ordinary and usual course, and there is no unusual or onerous contract, etc., etc. And again, your lordship has no guidance from the Kuwaiti experts as to how this clause would be interpreted. Turning to page 61, your lordship sees clause 9.1. This is one of the three warranties that was relied upon in the RFI. So this is an old warranty. I don't take objection to it. And you can see that the obligation is to conduct yourselves in all material respects in accordance with all applicable legal and regulatory requirements.
Yeah.
Second limb of that provision in relation to no officer or senior manager for having committed a crime is not, I think, something your lordship's going to have to trouble himself with. It's the first three lines of that clause which may be applied. Page 63. The company legally and or beneficially owns or has a license to use all intellectual property and rights in information used currently in or necessary to carry on the business conducted by the company. We say that the point of that clause is to protect the buyer from the risk
You've muted. Yeah. Can't hear you. Try now.
We cannot hear you, Mr. Hugh. If you could please get the laptop closer to you, maybe, or the camera. We still cannot hear you. If you could maybe disconnect and reconnect again.
My lord,
Can you hear us?
I can hear you. Can you hear me?
Yes.
I can hear you now.
The magic of logging on and logging off appears to have worked for us.
We lost you just after you started talking about 12.8. You had read it. You were making a point about it.
Thank you. So, having read 12.8, I was saying that the warranty seeks to protect the buyers from risk that at the time of the SPA or at the time of completion, the company was infringing IP rights. What it does not do is provide any assurance that such IP rights or licenses will transfer on completion. It is a warranty that we are not in breach, rather than a warranty that we will transfer.
Yep.
And then at page 68, there are two warranties at 18.2 and 18.3. (18.2) is an information warranty. Your lordship has no guidance from the experts as to how this provision would be interpreted. And there is simply no factual evidence or quantum evidence as to what loss would flow from a breach of this warranty. If I sell Mr. Lovett my car and I fail to disclose that there is a small cigarette burn on the seat, I would say to your lordship, what loss flows from that, because Mr. Lovett would have bought my E-Type Jaguar in any event. And so what your lordship has is your lordship does not have any evidence, factual or expert, as to what loss would flow. And in 18.3, again, your lordship has no guidance from the Q80 law experts as to how this might be interpreted, or to what might reasonably, or what the Q80 court might consider the words might reasonably have been expected to influence the decision of the buyers to mean. That is obviously a threshold test. Reasonably expected to influence the decision. Where would the Q80 court set that threshold? That is the SPA. There is then a disclosure letter in relation to the SPA. That is at page 78 and following.
Yeah, I have that.
I'll show your lordship page 79. There are in 1.1 carve-outs. (1.1a) is the disclosure letter itself. 1.1b is disclosures made to the buyers by any of its professional advisors. And then at 1.3, there are some deemed disclosures. And those include things disclosed in writing by the sellers or KPMG. And I contrast 1.3a with 1.1b, because the 1.1b does not require the disclosure to be in writing. And 1.3b includes any information in the virtual data room. And you can see that there's a computer disk which has been delivered and that delivery has been acknowledged by an email dated the 13th of May 2019.
Where's the reference to that?
It's 1179 of the bundle.
No, where's the reference on page 80 to the?
Oh, I'm so sorry. I'm down in 1.3b, so I'm in the bottom left-hand corner of the page.
Virtual data room, okay.
Yeah.
And so you gave me a page for something.
I gave you a page for the email and also the index to the data room. It begins at 1179.
Yep. Mm-hmm.
In the remaining few moments, I wanted to, or the remaining 10 minutes, I just wanted to show your lordship how the case developed. And we're going to have to go to the G bundles. The G bundles are the chronological run of bundles.
Yeah.
And your lordship will recall that completion occurred on the 26th of June.
Yeah.
2019. And the first document I want to show your lordship is the first notification, which we find at page 1500, G 1500.
Mm-hmm.
It's a letter written by Mr. Alfalar, who you're going to hear from.
Yeah.
Dated the 2nd of March 2020.
Yes.
He refers to the sale and purchase agreement. He says they have conducted an audit. They've reviewed various documents and that they want to hold back materials set out in the appendix to that letter.
Yep.
And if your lordship turns the page to 1501, there are 16, I misspoke. There are 16 breaches. They total, if you see the bottom right-hand corner, 2.7 million odd Q80 dinar. and that number has been reached often by applying a 12 times multiplier to the losses. So a nice easy example is if your lordship can see 2.8 in the middle of the page.
Yes, I have a difficulty in turning this page sideways.
Ah,
But don't worry, I'll look at it vertically.
sorry. Well, I was simply going to show your lordship that in 2.8, if you want to try and read it upwards, that the value column has 1, and the value multiplier column has 12 in it, and the total has 12. So the way that the loss has been arrived at is applying a 12 times multiple.
Yeah.
That's the only point I wanted to show you.
Yeah.
Total of 2.7 million dinar being claimed in that letter. And then if I can get your lordship to electronically turn the page to 1502.
Yeah.
This is the second notification letter sent some 3 days later on the 5th of March 2020. It's not explained in the witness evidence why, after a delay of 8 months, 2 letters follow in very quick succession. One might think the obvious thing to have done is to sit on one's hands for 3 days and combine the letters into 2, but that's not what they do. They send these 2 letters in quick succession. Mr. Al-Falah again signs the letter at 1502, identifies further issues, and your lordship can see those further issues. I should be clear that the issues raised in this letter are different from and in addition to the issues raised in the previous letter we were looking at.
Yeah.
So again, your lordship can see on 1503, the attachment to the letter, 18 complaints, totaling, looking at the bottom right hand of the document, and I appreciate your lordship is looking at this at an angle, so you're probably looking at the top right hand corner of the document, a number of 2.406 million.
Yep.
That's the total claimed here. And just pausing there, the combination of those 2 letters is that in the course of 4 days, my clients have been notified of 34 claims with a value of 5.1 million. Which of course wipes out the holdback amount. And your lordship will also have noticed the lack of specificity in the tables which you were just looking at.
Yep.
Can I then take your lordship to 1506? Mm-hmm. This is the third letter. This letter is sent on the 25th of June 2020. That is 1 day before the holdback amount is due to be paid.
Yeah.
And in the interest of time, I'm simply going to flick through it. It identifies 27 different complaints. So we have seen in the 2 previous letters, 16 and 18, I had 34 complaints. By June, that 34 had dropped to 27.
See, these are not in addition.
No, these are a recasting of the two letters of March, but they're numerically different, both in terms of the number of complaints, 27, not 34, and the quantum has dropped from circa 5.1 million to circa 4.7 million.
Yeah.
And the other thing, and I'm given time, I don't want to bore your lordship with it, but if your lordship looks at how the case is put in this letter, they only rely on a breach of two provisions of the SPA, and that is clause 1.1b of Schedule 5 and also clause 9.1 of Schedule 5. Those are the only two provisions identified in this letter.
Where do I see that?
Your lordship can see that at 1507.
Yeah.
Second line on 1507, you can see 1.1b.
Yes. Yeah.
And staying on the same page and going to the penultimate bullet point beginning on 6 September 2016, you can see on the fourth line of that paragraph, pursuant to clause 9.1.
Yeah.
And those provisions, or their short form, are recycled throughout this letter. There's a third provision which is relied upon, and that's at 1509. Bottom bullet point, and that is clause 12.8b.
Yeah.
That's the third one. But what is interesting is by the time we get to the response to the RFI, that has been dropped, but it is there. So in this letter of June, three provisions relied upon.
Yeah.
With a total value of 4.7 million. Not being content with that, further claims are then advanced in a letter dated the 15th of October 2020, and that's at 1532. And your lordship can see in that letter that they conclude that they're entitled to hold back a further 2.597184 under clause 10. That's the fourth line. This brings our total entitlement to Q80 dinar 7.7 odd million. And then there is behind that a further schedule of complaints.
Yeah.
Pleadings then follow. In the pleadings, and I'm going to do this briefly, Mr. Lovett's team does not, in their defence, identify with any particularity what they say the breaches are. The best they do is to identify, and let me just show your lordship this, if I may. If I can take your lordship back to the bundle A, the defence.
Page
92 of the bundle. Sorry, page 91, I think is probably where we need to start.
Yeah.
Paragraph 17.
Yeah.
They deny paragraphs 23 and 24 of the particulars. I know your lordship hasn't seen that, but that is the essence of the complaint. Yeah. And then you can see 17A sets out some provisions. And that's the provisions we've looked at already. And then if we invite your lordship to turn the page to page 92.
Yeah.
And then 92B, Roman 2. The defendant's decision on the holdback account was taken on notice. The claimants received no less than 3 written notices before deductions were made. And then there's reference to the 25 June letter. It's 5 pages and sets out various breaches under the SPA of clauses 9.1 and 12.8 and clause 4.1. So in the defence, they rely upon the 25th of June letter, which we looked at, and say there are 3 breaches of the SPA and a further clause relied upon. That is their answer in the defence. There is then the response to the RFI, which sets out the points relied upon in great detail. And then what happens, and we can develop this in due course, is that the claim begins to reduce dramatically ahead of the PTR, which your lordship heard. And the consequence of where we are now is that the claim asserted in the letter we looked at was north of 7 million. That was the letter of 15 October 2020. The claim now advanced by my learned friend has reduced quite considerably to a figure of 2.265 Q80D. And that sum of 2.265 is supported by the position paper my learned friend served. And we say that each of those counterclaims are flawed and that the claimants are entitled to the full amount of the holdback, and that they're also entitled to their additional claims. My lord, I've taken the last bit rather shortly, but I wanted to make sure that I did no more than an hour. So,
yeah. Well, thank you very much. Now, Mr. Lovett, at some stage in the next half hour, I'm probably going to get taken away. But do you want? So, would you prefer to start now, or do you, because we're into the morning break? You took longer because of the technicalities this morning. How do you want to do it? Do you want to start now, or do you want to have a break now?
Would you mind if, and probably the transcribers will be happy with a break now. Would you mind if we broke now, my lord? And then I recognise that we can either have a longer break or I recognise that if we have the shorter break, which is more normal, that I will be interrupted, but I'm happy either way.
Well, I tell you what, shall we break for 10 minutes now? Is that enough for the shorthand writers? I think it probably is.
Perfect, thank you.
And then we'll resume and see how far we get without interruption.
Thank you, my lord.
Thank you. I've lost all the commands that enable. Right, is everyone back in place? Yeah, Mr. Lovett then.
Thank you, my lord. My lord, as you would expect, the SPA was concluded on the basis that the defendants would be relying on the various warranties given by the claimants. The warranties in the SPA, we say, are not unusual or unduly onerous. The fundamental warranties are set out in Schedule 5, Part A of the SPA, and the general warranties at Schedule 5, Part B. I know that Mr. Lyons has taken you through those warranties in some detail in his opening, but just to briefly summarize those, the fundamental warranties are that the claimants warranted that the company was in full compliance with all regulations, save as to the extent set out in the disclosure letter, and also that the disclosure letter provided full details of any goods and services supplied by the company by any of the claimants or any person connected with the claimants. For the purpose of the transcript, that is the SPA Schedule 5 Part A, Fundamental Warranties is Clause 3. Under the heading of General Warranties, it was warranted that there was no material adverse change in the financial or trading position or prospects of the company, and no circumstances giving rise to such a change. It was warranted that the company had at all times conducted business in all material respects in accordance with all applicable legal and regulatory requirements, that all information supplied to the defendant since indicating its interest in acquiring the company was true and accurate in all respects, and that there was no fact or matter not disclosed in writing which rendered any information supplied untrue or misleading because of an omission or ambiguity or for any other reason. In terms of the account specifically, it was warranted as a general warranty that the accounts were prepared in accordance with applicable law and IFRS. They showed a true and fair view of the assets and liabilities of the company at each relevant accounting reference date. They showed a true and fair view of the profits or losses of the company up until the accounts date, which is the 31st of August 2018, and that they were not affected by any extraordinary, exceptional, or non-recurring items. As for the company's intellectual property, the relevant general warranty stipulated that the company legally and/or beneficially owned or had a license to use all intellectual property and rights in business information as defined, or school information as defined, owned or registered by the company, and I quote, in the manner currently carried on and to fulfill any existing plans or proposals, end quotes. Mr. Lyons has habitually referred to the holdback amount as being due on the 26th of June 2020. What he fails to note is that the release of the holdback amount was contingent on there being no warranty breaches as per the terms of subclause 6.2d. Mr. Lyons has also objected to losses being claimed which had yet to be incurred, and he refers to these in his written openings at paragraph 43. His suggestion that the spirit and purport of clause 10, that losses must have already been incurred, is a nonsense, which is patently at odds with clause 10, which reads as follows, and this is clause 10.1. AJIAL for itself and on behalf of Talal shall reimburse fully the buyers and the company for any and all losses which the buyers or the company may suffer or incur, not has suffered, but may suffer. And if one looks, if I could just take you briefly to that clause, which is at page 38 of the bundle.
Yeah, I have it. Yep.
So I think, is it possible to make it larger on the screen, Freddie?
I've got it in hard copy in front of me.
My lord, I'm afraid I need to just pick that up in hard copy, if you'll forgive me. So at 10.1, so the obligations, the right to reduce from holdback. If I can take you to 10.1b, it talks about any losses to the buyer as a result of leakage adjustment amounts determined after the completion date in accordance with clause 5.5 above, and then 10.1c, in the event that the number of actual enrolled students in the existing schools falls in aggregate below 6,000 students during the semester ending 31st of August 2019. Although those two claims are not pursued as breach of warranty claims, the context of that wording is very clear in my submission, that the warranties extend to losses which may be suffered and not which have been suffered. Likewise, Mr. I'm sorry, I've just lost my place. Likewise, the claimant places great reliance on the alleged oral disclosures, which they say means that there was no breach of the relevant warranty. The claimant's position, and so much of their witness evidence, is somewhat redundant. This is because in subclause 9.1 of the SPA, only matters which are fully, fairly, accurately and specifically disclosed in the disclosure letter provide a defence to what would otherwise be a warranty breach. And only disclosures made in accordance with clauses 1.1b, 1.3 and 2 of the disclosure letter can limit the representations and warranties in the SPA. In other words, the only form of disclosures that alter the warranty position are those captured as matters referred to in written correspondence or attached documents from the claimants or KPMG on or before the 15th of May 2019, written uploaded material into the virtual data room, specific matters set out in Schedule 1 to the disclosure letter and recorded on the computer disk annexed to the disclosure letter, matters or information in the management accounts, or any matter which was reported to the buyers on or before the 15th of May 2019 by any of its professional advisors. Your Lordship will of course note that all of the above are written disclosures that could, and if they'd happened would, be contemporaneously evidence and before this court. That is not the position here. I should note for completeness, my lord, that the defendants provided the claimants with voluntary disclosure of all of the above categories of documents, except to the extent that they're in the custody and control of the claimants, and that notwithstanding that disclosure, the claimants are still unable to evidence their position, which in my submission tells us all we need to know about the position being run by the claimants. Now, there is a suggestion in Mr. Lyon's opening of the abandonment of claims. And although he suggests with some hyperbole that large numbers of claims have been raised and then abandoned, the reality is that only 3 claims have been abandoned since these proceedings were commenced. And as your Lordship will know from our written openings, these claims only remain live because of the claimant's unwillingness to sign the consent order that the registry suggested following the defendant's submission of a notice of discontinuance be signed. To make the point he wants to make, Mr. Lyon divorces his assertion from its context to try and give it some more force. The reality, however, is rather less helpful to the claimants. The evolution of the defendant's claims is nothing more than testament to the fact that the defendants have been acting in good faith, assessing all the information known to them at the relevant time in assessing their entitlements under the holdback amount. In short, pre-proceedings, claims fell away when the defendants engaged in further evidence gathering, analysis, including through external input, and thinking about the cost of asserting certain claims. And the latter point of the cost-benefit analysis is why the defendants opted against pursuing certain claims. In other words, the candle was simply not worth the light after considering the associated expert and legal fees. As to the 3 claims that were dropped in these proceedings, the defendants, with the benefit of independent advice, formed the view that they were not sustainable, and the defendants, to their credit, rather than trouble the court, consistent with Mr. Al-Fallah's testimony that all the defendants intend to do is to withhold that to which they're entitled, instructed the withdrawal of those claims. As to the question as to why the claims were not abandoned sooner, the answer is in no small part attributable to the claimant's failure to engage on the substance of the claims. And I'd like briefly at this point to set out the evolution for your Lordship, because in many instances, what's more interesting to note about Mr. Lyon's factual summaries is what he chooses not to say. The defendants, as Mr. Lyons explained, issued 3 notices in advance of deducting the holdback amount. The first notice was dated the 2nd of March 2020, and Mr. Lyons has taken you to that. It identified 16 observations and proposed entitlements and notes that this is an official notification for your prompt action. There was no response from the claimants to that notification. I should pause there to note that Mr. Lyons also suggests that the notices did not give the chance to remedy and/or fail to suggest how to remedy the issues. The first point to make in response is that the claimants didn't engage at all, so one could ask rhetorically what difference it would have made. The second is to note that it was not for the defendants to devise remedial action. That's not what the SPA says, and that's not what the SPA requires. The second notice was dated the 5th of March 2020. It identified 18 observations and proposed entitlements, and also noted that it was an official notification for your prompt action. Again, there was no respondence from the claimants. The third and final notice was dated the 25th of June 2020, and again, Mr. Lyons took you through it in his opening. That set out further detail on the entitlements communicated in the first and second notices. The themes will therefore be familiar to your lordship, being those themes that are before the court. The third notice ends. If you have any questions or you would like to discuss our decision further, then please do not hesitate to contact me. There was no response from the claimants until the 20th of July 2020, when the claimants wrote a high-level letter threatening legal action if the entire holdback amount was not paid. The defendants then responded on the 17th of August 2020, and if I could take you to that document, my lord, that's at 1515 of the hearing bundle. It says, we're disappointed that AJIAL has failed to substantively engage with any of the points we put forward in our letter of the 25th of June 2020. In our letter, we set out a detailed summary of all breaches of the SPA committed by AJIAL and invited you to revert to us with any queries. In response, you have issued a blanket denial of any breach under the SPA, and you have not queried the amounts that we have held back or questioned our rationale for doing so. Making a short demand without any explanation at all for the full amount is not helpful in understanding precisely why you think we are wrong. We would like to emphasise that we wish to resolve this issue amicably through constructive dialogue between both parties. To this end, we would like to invite you on a without prejudice basis to a video conference to walk you through our justifications and discuss any concerns that you may have. A meeting was then held on the 26th of August 2020. The claimant was unwilling to discuss detail or engage beyond anything else other than demanding a full payment of the holdback amount. The defendants tried again, a second meeting being offered and held on the 22nd of October 2020. As before, the claimant was unwilling to discuss detail or engage in anything beyond demanding full payment of the holdback amount. Your lordship will also have seen the correspondence that was sent on behalf of the defendant's previous law firm, or our law firm, Gibson Dunn, and that letter again illustrates the claimant's conduct and attitude prior to commencing these proceedings. And once again, my lord, if I could take you to that document, it's at page 1588. In the third paragraph of that letter, it says as follows. As you will see from a fair reading of the attached correspondence, there can be no suggestion that AJIAL is somehow in the dark as to the rationale behind withholding the holdback amount. Our client's correspondence has been transparent on its thinking, and a detailed explanation was provided in our client's letter of 25th of June 2020, to which no substantive response has been received. Likewise, our client was willing to take AJIAL through and explain the detail at meetings held on the 26th of August and the 22nd of October 2020. On neither occasion was AJIAL prepared to explain, explore, or discuss the substantive points. AJIAL has therefore stonewalled our client's repeated attempts to understand AJIAL's rationale for resisting what is a good faith and substantiated decision to withhold the holdback amount. In a similar vein, you will note that our client has been frustrated in its pragmatic attempts to avoid litigation. You will, for instance, have seen that we have previously suggested mediation as a cost-effective option to bring the parties together and see if there's a way to avoid recourse to the expense of DIFC court proceedings. Disappointingly, however, AJIAL's response was to try and use our good faith offer of mediation as a tool to renegotiate the dispute resolution clause so that claims could be brought by arbitration rather than the DIFC courts, to threaten litigation in the Kuwaiti courts contrary to the existing dispute resolution clause, and lastly, having failed to secure our client's compliance to demands 1 and 2, to ignore our correspondence of the 7th of December and wait 7 months before instructing you to send your letter of the 15th of July. We say, my lord, that it's against this background of perennial non-engagement and avoidance, and indeed we would say it's arguably an active obstruction of any substantive discussion on the merits, that the relatively limited evolution of the defendant's case is not only defensible, but almost to be expected. Turning now to the claimant's suggestion that there's been significant movement in the warranties relied upon between the pleadings and the position paper. The position paper, it will be recalled, was prepared at Mr. Lyon's request, and it was agreed that it would act as a compendious set of particularized breaches of warranty, and that it would pin everything down to one document. And I think those quotes, my lord, are your quotes from the PTR. That having been done, Mr. Lyons now tries to suggest that the defendants are somehow offside for referencing the warranties that the evidence shows to have been breached. In fact, there's been no wholesale repleading of the case, nor any attempt to materially alter the defence, as Mr. Lyons suggests in his written openings. All the claims in the position paper are in response to the request for information, save as to 3 claims that the defendants discontinued. Only 7 warranties are cited and relied upon in the position paper. 5 of those warranties are noted in the defence, and for the transcript, that's Part A 2.6, Part A 9.1, Part B 1.1, Part B 12.8, and Part B 18.3. 2 of the warranties came to the fore and became part of the defendant's case as the fact and quantum expert evidence was submitted, which made clear a breach could be supported. And that related to the subclause 3.1 intercompany arrangements. That arose out of Mr. Rashad's 4th witness statement, which, as I mentioned earlier, was submitted by the claimants on the 15th of June 2023, which, my lord, you will recall was the same date as the PTR. No notice was given to the claimants, to the defendants during the PTR that Mr. Rashad would be filing an additional witness statement. And it wasn't even mentioned that one was in contemplation, far less that it would be served that evening. In that statement, Mr. Rashad set out a hitherto unmentioned intercompany accounting arrangement between AJIAL and DAS. Mr. Matthew, in his response statement, which is his 3rd witness statement at paragraph 8, highlights that the failure to mention this was, to his mind, contrary to the Part A fundamental warranty at subclause 3.1, which relates to intercompany arrangements. That's a correct position in our submission and adopted by the defendants as an alleged breach. The intercompany arrangement breach is relevant and applicable to a number of claims, as witnesses and expert evidence has revealed that there are intercompany arrangements between AJIAL and DAS, but they were not disclosed or explained to the buyers pre-completion in accordance with the SPA. In relation to subclause 3A, it's Miss Record who has highlighted the Part B general warranty at subclause 3A, which is the no material adverse change in financial position or prospects of the company, appears to have been breached in relation to the top business claim, and it's only in relation to that claim only. It's perfectly proper in our submission for the defendants to adopt Ms. Record's analysis, which is set out at E/4494 at paragraph 4.2.4 of her report. In terms of how the additional alleged breaches have altered the defendant's position, the reality is that it's marginal, permissible, and causes no prejudice to the claimants. Firstly, there are no new claims. All of the warranties relied upon were in play before the position paper was lodged. The position paper is only but the requested compendium that nails everything down. The warranty breaches engaged by 4 of the 17 claims are exactly as they were in the request for information. Of the residual 13 claims, 3 are regulatory claims. Of the 3 regulatory adjustments, 2 are instances where a Part B subclause 18.3 breach has been alleged, in addition to the Part A 2.6, which is compliance with regulations, and Part B 9.1, which is the compliance with legal and regulatory requirement breaches set out in the response to the RFI. The additional breach in our submission is justified by the claimant's failure to highlight any disclosure of relevant documentation, for example, the Ministry of Education inspection reports and the Ministry of Education notifications in the data room and/or otherwise on disclosure. In respect of the non-compliance with the applicable fire and safety standards claim, a breach has been supplemented by reference to breaches of Part B, Clause 18.3, which refers to incompleteness of information, Part A, Clause 2.6, compliance with regulations, and Part B, Clause 9.1, compliance with legal and regulatory requirements. That is a matter which is confirmed by the Kuwaiti law experts, and the references are Dr. Al-Salili, F1/1551 at paragraph 18.1, and Mr. Al-Asami, and the reference is F/2/579 at paragraphs 30 to 32. Those observations are that fire regulations are binding and should have been complied with. So all we've been doing is simply contextualizing the financial breach, which is the provision for compliance with the concurrent regulatory breaches, in other words, a failure to act. In terms of the 10 accounting claims which have changed, in 8 of those claims, the only amendment has been to allege, relying on the warranty raised by Mr. Matthew in response to Mr. Rashad's 4th witness statement, that there is a Part A Clause 3.1 intercompany arrangement breach, in addition to the Part B Clause 1.1 accuracy of accounts breach. As I mentioned earlier, it's now clear from the claimant's evidence that intercompany arrangements were in place, and they failed to set out the details of their head office arrangements in the disclosure letter or as required otherwise by the SPA. In terms of claim number 2, which is the overstatement of income on the ICS book sales, that's a breach of Part B, Clause 1.1, the accuracy of accounts, and now, based on the evidence of Ms. Record in her expert testimony, more properly described as a breach of Part B, Clause 3A, events since the reference date, and Part B, Clauses 18.2 and 18.3, which relate to the accuracy and completeness of information supplied to the buyers. In terms of claims 24, which is the software licenses claim, the breach relates to Part B, Clause 1, which is the accuracy of the accounts, and is supplemented by the Part A, Clause 3.1 breach, which is the intercompany arrangements, and the Part B clause 12.A, which is the intellectual property breaches, which are now justifiable on the basis of Mr. Rashad's evidence and the relevant IP licenses, which were not capable of transfer. The reference to that is Bundle D /2/262 to 263 at paragraph 156. Again, there's no proper basis in our submission for criticism. The claimants requested the position paper, we prepared it, and the claimants are objecting only because the position paper has done what it was supposed to do. In other words, it's pinned everything down, as your lordship suggested at the pre-trial review, and provides and shows entitlement that is supported by the witness, expert, and contemporaneous evidence. Turning now to alleged failures to notify, Mr. Lyons also takes a point in relation to the marketing staff claim and the fire safety claim. His submission is essentially that these claims cannot be brought because they had not been raised before the holdback amount was due. I've already dealt with why the holdback amount was contingent and not due on the 26th of June 2020, but dealing more pointedly with the notice point, in terms of the marketing staff claim, which is the marketing and advertisement services, that claim was listed in the observations and proposed entitlements set out in the 5th of March 2020 written notification at entry 1.7, and the reference to that is Bundle G /96/1503, and the marketing and advertising services costs are referred to in the second paragraph of the 25th of June 2020 letter, and that reference is at Bundle G /96/1506. The opportunity to cure, which is what the clause 10 requires to the extent it is possible, was therefore afforded to the claimants. The fire safety claim, however, is different. The claimants were made aware of the fire safety issue on the 12th of December 2017, which is the date of the conditional license. They did nothing to address that issue. They failed also to disclose this fact in the virtual data room or otherwise. In those circumstances, there was clearly no opportunity to provide an opportunity to correct because of the claimant's own failure to disclose, and there's no prejudice because it's impossible to correct those circumstances, and those circumstances are also of the claimant's own making. The claim also remains sound on the wording of clause 10, which places no limitation on times on claims, and we say they can be made until the holdback amount is paid. Mr. Lyons then turns to the EBITDA multiple and attempts to undermine the multiple 11.9 times stated by Ms. Record to be the appropriate multiple and relied upon by the defendants. This is done by reference to Mr. Ahmed Al-Fallah's witness statement, noting that's. I'm sorry.
You went mute briefly.
Can you hear me? Can you hear me now, my lord?
Oh yes, it's just a few words I missed, but don't worry. I think I know what you're saying.
So that the observation by the claimants was that the multiple that had been used was a 10 times multiple due to the allocation of the KD3M to the value of the new schools. But what the claimants haven't done is omitted material. What they have done is to omit material aspects of Mr. Al-Fallah's evidence on the point, where he states clearly that the final offer put forward by the defendants implied an enterprise value for DAS of 18.46 million Kuwaiti dinars and an enterprise value stroke EBITDA multiple of 11.94 times. In other words, that's not 10 times, but 11.94 times. And for the record, that is at Mr. Al-Fallah's first witness statement, paragraph number 17. Ms. Record, who is our accounting expert, has also calculated the implied multiple of the actual purchase price by taking the purchase price of 18 million Kuwaiti dinars, adding the net debt, 461,321, and dividing the total of 1 and 2 by EBITDA. That avoids a debate over the value to be allocated to the new schools, which was not a matter agreed between the defendants at the time of purchase, and reflects the certain, i.e. total price being paid, the EBITDA and the multiple, which comes out at 11.9, and that is completely consistent with Mr. Al-Falah's evidence. My Lord, having read the position paper and noting the focus of the next few days, I'm loath to take you through the warranty breaches once again this morning, and I know obviously Mr. Lyons has done that already. I think you're alive to everything that's pertinent, and as our position paper makes clear, I don't want to do anything more at this stage than re-emphasise to you that there are themes to the claims, as set out at paragraph 21 of our written openings, that the defendant's allegations are all consistent with not only the underlying evidence, but the independent testimony of Mr. Al-Asami on Kuwaiti law and Ms. Jackie Record from a quantum perspective. On the bank guarantees claim, I also don't intend to spend any real time on this. Our position is clear. We accept and have long accepted a liability to the extent that the costs incurred can be evidenced. That's right and proper, given the accounting requirements, that costs cannot be reimbursed until and unless they are properly substantiated. The claimants initially cooperated and submit some evidence of their expenses, and on the 7th of July 2020, the defendants, as a consequence, paid the claimants 2,536 Kuwaiti dinars on the basis of those expenses. In his second witness statement, Mr. Rashad has provided further supporting details, which he states will be supplemented in due course. That's at his second witness statement of paragraph 164. That was the first time since July 2020 that the claimants engaged with the need to provide evidence of the charges that they claim to have incurred, and unsurprisingly, the claimants have not supplemented the supporting details as they promised to do. So where does that leave us? It leaves us with a claimant's claim value of 25,275.28 Kuwaiti dinars, which makes no deduction to reflect the amount that we've already paid. In terms of the position set out in Mr. Rashad's second witness statement, the claimants have entirely failed to evidence the cost and/or interest allegedly incurred in respect of maintaining the guarantees. All that's provided is an Excel document with Mr. Rashad's non-evident summary of the costs and copies of the letters of guarantee. There is consequently no documentary evidence before the court that any costs, in addition to those that have already been paid to the claimant, have been incurred. And as a result, the sum that should be ordered against the bank guarantees, we say, is zero. As to interest, even if a positive sum was owed, which is not the case given their failure to serve evidence, no interest would be due because the non-payment to date is solely attributable to the claimant's unwillingness or perhaps their inability to provide the evidence necessary to reimburse those alleged guarantee costs. Turning now briefly to issues of Kuwaiti law, as summarised by Mr. Al-Asami, the legal expert for the defendants, in his reply expert report, it does appear that the Kuwaiti law experts are broadly agreed on three things. The first is that the quantification of damages for breaches of warranty under Kuwaiti law. The second is in relation to the manner in which interest is awarded on damages under Kuwaiti law, and in particular the position that interest is only levied from when the amount owed is known and clear, and when the sum to be paid is not in dispute. The third is that when the penalties for failing to comply with laws and regulations applicable to schools in Kuwait are set out in a ministerial resolution, which is Ministerial Resolution 46601 of 1967. The main area of disagreement between the experts relates to the legal effect of the Ministry of Education inspection report dated the 17th of March 2018. And in his first report, Dr. Al-Salili appears to suggest that there are no consequences for failing to comply with the inspection report, whereas Mr. Al-Husseini in his first report is clear that any material breach of an inspection report could lead to penalties, including withdrawal or suspension of the school's licence under Article 19 of Resolution 46601. It's understood that Mr. Al-Husseini and Dr. Al-Salili were attempting to agree the effect of the inspection report in their joint discussions, and that was where they got to independently and is reflected in their draft of the 10th of July 2023, which provides that inspection reports and notifications are an introductory measure or an action by the administrative authority. Mr. Al-Husseini has explained to this firm that he was and is happy to concede that reports and notifications may not be administrative decisions, because ultimately the key point in our submission is that notifications and inspection reports are regulatory in nature, they're binding, and they must be complied with because non-compliance is contrary to applicable law and regulations, and penalties can follow. And just in closing, my lord, and whilst I'm on the subject of the Kuwaiti experts joint report, I will be very brief on this submission. But this morning, Mr. Lyons described the issue with the Kuwaiti law expert reports as a tussle. We say it's a little bit more serious than that, insofar as Mr. Lyons accepts that his firm ghosted, by which I understand he means ghost wrote, the changes made by Dr. Al-Salili to the draft, which was circulated at 10:45 on the 10th of July. Now, it's not my job to teach Mr. Lyons how to litigate, and I don't wish to lecture him, but clearly in my submission, there was an error of judgment on his firm's part in taking the view that such extensive input, indeed ghostwriting, is appropriate in circumstances where two experts are trying to conclude their reports. It's not something that's tolerated in the English High Court, and indeed there is case law on it. But I don't wish to push it any further than that. I just wanted to register the fact that I think it's more than a tussle. It is, in our submission, inappropriate for either firm to take any drafting responsibility for a joint experts report. Your Lordship, with my and hope that when the experts do, it is hoped, following your direction, submit their reports on Wednesday, that Baker and McKenzie do not have any input into that joint report and the writing up of that report. To sum up, my lord, this is a case in which the claimant's position is predicated on a misreading of the SPA and the perennial omission and or overstatement of relevant facts, which we say will become increasingly apparent as the trial progresses. My lord, that was a quick trot through my submissions, but if I can be of any further assistance, that concludes my openings.
That's very helpful, thank you. And you've managed to catch up considerably on the time that we've understandably taken this morning. So at that stage, at that point, then, should we stop for lunch? Is that in accordance with the timetable? I think. And it's now 11:50, 2:50 your Dubai time.
2:50, my lord, yes.
We're only 5 minutes behind schedule, so can we resume at 15:30, or do you want a few minutes more?
15:30 will suit the defendants, my lord.
Yeah, and we go straight into the claimant's first factual witness. Yeah.
Could I ask, my lord, which witness they're proposing to call first? I'm still not sure that I know.
For Mr. Love and the court's benefit, Mr. Rashad is going to be called first.
I assume that, yeah. Very well.
Thank you.
We'll stop now and resume at 15:30 your time.
Can I just check what time that is in the UK? Is
12:30. Is that right? 12:30 UK time.
Right.
This afternoon's session is 2.5 hours. I think the shorthand writers would need a break of 10 minutes or so in the middle of that. So should we aim after about an hour and a quarter at a convenient point to have a short break? Is that all right, shorthand writers?
That's very kind, thank you.
Thank you. Very well. Yes, Mr. Lyons.
My Lord, may it please you, I call Mr. Mahmoud Saad Rashad. Just to explain, Mr. Rashad is in a separate room in my office, and there is a slight echo as my voice travels to a separate room, but I think we've solved that.
Is he alone in the room?
He's with Miss Dumar, who is one of my associates. She was going to stand with him while he is sworn, and then she was going to leave him.
Yes, that's fine. Unless there's anything else, I'll ask the court clerk to administer the oath. Saeed.
Yes, of course. Yes. Mr. Rashad, will you be swearing or affirming today?
I'm here.
I'm sorry, I cannot hear it. Will you be swearing?
هل ستحلف سيد محمد راشد؟
محمود سعد.
الاسم الكريم لو سمح.
محمود سعد.
محمود سعد. هل ستحلف اليمين؟
إن شاء الله.
Yes, he will.
Yes,
Can I see a copy of the Holy Book, please?
سيتم استعانة بنسخة من القرآن.
I'm really sorry to interrupt. Is there an interpreter? Because if there is, I can't hear.
This is AJIAL. This is the interpreter. Yes.
You're very, 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 very low volume. I can barely hear you.
Okay.
I don't know whether the judge can hear.
I can just hear, but can you turn
Yes,
your
very
volume
low.
up?
This is the loudest from my end. Could you? Am I audible now?
No, that's not audible enough for me to transcribe.
If it assists your lordship, the idea is that Mr. Rashad will try and give his answers in English. His English is good. Mr. Interpreter is only there in case of difficulty, although I'm conscious the interpreter will need to be sworn.
But are they in the same room?
No, there is a virtual link between my office where Mr. Rashad is and where the interpreter is.
Well, I don't think it's going to work if we have the interpreter as quiet as this.
I'll try again. Am I audible now?
No, not yet. Is it okay if we disconnect the headset and try to use the laptop's microphone?
What about now?
Yes, it's
Am
better.
I audible now? Is
Yes.
it better? Okay.
Mr. Rashad,
Mr.
Yes.
Saeed, would you swear the interpreter as well, please?
yes, of course. Mr. Adil,
Yes.
yes, please state your full name and occupation for the court's record.
Say that again. Sorry.
Please state your full name and occupation.
My full name is Adil Abdullah Salih Al-Haymi. My occupation is a simultaneous and consecutive interpreter.
Please repeat after me. Will you be swearing or affirming?
I'll be swearing.
Do you have a copy of the Holy Book?
I don't at the moment.
So is it okay if you just affirm?
Sure.
Please repeat after me.
Sure.
I solemnly declare
I solemnly declare
and affirm
and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Mr. Rashad,
Yes.
can I see your hand on the holy book, please? Thank you. Please state your full name and occupation.
Mahmoud Saad,
And your occupation.
CFO for AJIAL Group.
Please repeat after me. I swear by the Almighty God
I swear by my Almighty God
to tell the truth,
to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing than the truth.
Thank you.
Yes, Mr. Ryan. Sorry, Mr. Ryan. What's the position about me getting a copy of the transcript live? If nothing's been done about it, don't worry. Let's not hold things up.
My apologies. I had failed to talk to Mr. Wilkinson over lunch. Let me ask him to make inquiries, and we'll come straight back to you.
Thank you very much. Meanwhile, carry on with your examination.
Mr. Rashad, you have prepared 3 witness statements for this trial.
Yes.
And I'd like to show you those 3 witness statements in turn. The first witness statement for the trial is your second witness statement at page 225 of the bundle.
Yes.
That is your second witness statement, and it's dated the 14th of April 2023. 23, the 14th of April of this year. You can see that on the top right-hand corner. And if you turn to page 269.
Yes. Okay.
Is that your signature, Mr. Rashad?
Yes.
And have you had a chance to read your witness statement before coming to court today?
Yeah, I take my time to read it before I sign it.
And have you read it again today?
Yes.
And is the content of your witness statement true?
Yes.
Thank you, Mr. Rashad. Can we move now to tab 6 of the bundle at page 306?
Yes.
Is that your third witness statement dated the 2nd of May 2023?
Yes.
And is on page 318, is that your signature?
Yes.
And have you had a chance to read this witness statement before giving evidence today?
Yes, I take my time to read it.
And is the contents of this witness statement true?
Yes.
And then could you go to page 338 in the bundle?
The 8?
338, tab 9 of the bundle you're looking at.
338, yes.
Is that your fourth witness statement? You can see that on page 338. That's your fourth witness statement, Mr. Rashad.
Yes.
And if you could turn to page 341.
Yes, it's my signature. Yes.
And is the content of that statement true?
Yes.
Mr. Rashad, thank you.
Thank you.
Before Mr. Lovett asks you some questions, I should just say this to your lordship. Mr. Rashad speaks good English and reads good English. And giving evidence, of course, is a nervous business. And he has arranged for his English witness statements to be translated into Arabic. And with your lordship's permission, he'd like to have the Arabic translation alongside the English, because that may assist him. Is your lordship content with that?
Mr. Lovett, any objection?
No objection. It would have been nice to have been told this before the witness was giving evidence, so we can at least sense check things, but I don't think it will make a material difference, so no objection.
Thank you very much.
My apologies to Mr. Lovett. My lord, with your permission, I'll pass the witness to Mr. Lovett for cross-examination.
Yes, certainly. If it helps, I've got no difficulty with your assistant staying in the room with the witness, so long as she's behind the witness and only intervenes to try and help find a paragraph or page as appropriate. Mr. Lovett, you're content with that, Mr. Lovett, aren't you?
I think it would be positively helpful, my lord.
Good. Anyway,
Thank you.
sure.
And my lord, I was just going to say that Mr. Rashad has the witness statement bundle in front of him, but I think we were relying on Mr. Lovett and his team to put the relevant documents on the screen.
Right. Well, yeah, we'll see how it goes.
Fingers crossed.
Mr. Rashad, good
Yes.
afternoon. Good afternoon
Good
to you. I'm going to ask you a few questions about your witness statements. If you have trouble understanding me, please do say.
Okay, thank you.
Just by way of introduction, could you tell me how long you've been working at AHG?
Yeah, I'm working with the Al-Jili family since 2005. I started as accountant, and then I grew up with the company until the senior accountant, chief accountant, accountant manager, finance manager, and then I become now the CFO after we established the Al-Jili Holding Group now.
Thank you. And how many disposals, business disposals, have you dealt with since you've been at AHG Group?
Sorry?
How many business disposals have you dealt with since you've been at the AHG Group?
You mean how many schools we have under Al-Jili Holding Group?
No, how many sales of businesses have you been involved in since you started at AHG?
We sell only Dar es Salaam, DS, Indian school and Pakistani school, but we do a lot of acquisitions since 10 years now.
And how many acquisitions would you say you've been involved in over that time?
We made acquisitions for specific AJIAL international company since 2013. It was 4 schools, including AJIAL Bilingual School, plus Indian Central School, plus K.S.C.C School, plus Safwa Arabic School. And then after that, we made an acquisition in 2016, including around 8 to 9 schools, including international British school and Arab school and Pakistani school and some special needs Arabic school. And then we become the biggest educational group in Kuwait. And then after that, I think in 2017, we made acquisitions for American-German school. It was a new brand in Kuwait. And after that, we established a new school in Maldives right now. Now it's under construction right now.
So you've been very busy, obviously.
Yes, always busy.
When you acquired ICS in 2013, how would you describe the diligence that you were able to do on that school? Was it easy or was it difficult?
You make what you mean again?
When you bought the Indian school in 2013,
Yes.
was your due diligence of that purchase, of that acquisition, did you
Yes.
find it easy, or were there things that were missing?
It was very easy because I do by myself and our team, internal team. It was maybe within 1 month we finished everything, including due diligence, and transferred all the rights to the Algeria family. Because we are in the market and we know everything about the educational market, that's why it was very easy to us to acquire a AJIAL company. It wasn't for school, not only to school, it was for school.
And all the information that you needed was available, is that correct?
Sorry?
All the information you needed when you acquired ICS was available to you?
Yes, it was available inside the financial information, inside the balance sheet, and like recruitment reports, and some report from the Ministry of Budget and Ministry of Economic. That's why, as I told you, we are in the market. That's why it was very easy to us to get the information and to understand the operation.
And all the information relating to the buildings, that was also available to you?
Available to us, not only for me, because as I told you, we was team in working with Algeria group. That's why it was very clear to us. We have somebody for the legal department. He take all the information about the building and about everything, and he told me he's satisfied with the information. That's why it was easy. And because also we are in the market, that's why we know sometimes after acquisitions, maybe you will face some small difficult or small problem. That's why, because of we have experience in this sector, that's why we can solve any problem in the futures.
Thank you. I'd like to take you now, if we can jump straight into some of the detail. I'd like to take you in to talk about the top business account. This was the receivable for 145,000 Kuwaiti dinars. Do you recall talking about this in your witness statement?
Yes, the top business, we signed the contract with top business in the company level, not in the school level. That's why it was for this school, and we have also another contract with another schools. For we have, as I explained to you, also we have another Indian school and another Pakistani school in different company, different subsidiary. That's why when we start this one, we credit the revenue direct with the Indian Central School, and we credit the current school for AJIAL company from the beginning. That's why every affection in the future, it will affect only AJIAL company, not the school.
Mr. Rashad, thank you. Sorry, and this was my fault because this is probably your first time that you've given evidence in a court proceeding of this type. But I wanted to flag that we are going to talk about the top business contract, but I have a number of questions, specific questions I would like to ask you about that contract. So I'm going to start with one question and we'll move on to separate questions. So I would be grateful if you could answer each of my individual questions.
Okay, I'm ready.
So now I know your view in your witness statement is that the amount of 145,000 was credited in full to ICS. That's correct, isn't it?
It's credited.
In September 2018, you credited the full amount as a receivable to ICS.
Yes.
And then I know that on completion.
Anyway, sorry for. Anyway, we are talking now about information since more than 4 years or 5 years. That's why we try to remind what happened exactly at this time, but my team, not direct by minus.
Yeah, I understand that. I understand it was a long time ago, so you've had to remind yourself with documents, but you agree with me that that full amount was credited to ICS in September 2018.
Yes.
And I also know that your position is that upon completion of the sale, that amount was then netted off as an intercompany accounting exercise. That's also correct, isn't it?
No, already it's the full amount from AJIAL current account in the schools. That's why it's already at the Indian school, they already get the benefits from day one, and we already debit the AJIAL company accounts from the day one.
Yeah. So I'm talking now about the contract. So I'd like to ask you a few questions about the contract.
Okay.
Do you accept that the contract was identified as a material contract in the SPA?
What do you mean the material contract?
It was, we can turn to it as bundle reference number 72. It was listed as a material contract in the SPA. Do you recall that?
Sorry, bundle reference 72.
It's page 72, my lord.
Yeah.
Can you see that? I'll ask for it to be. You can see that. I can read it.
I need some help.
Can you zoom in by any chance?
Can you zoom in, please? This is disclosure letter.
Yep. Let's just go, we'll go to the top of the page so you can see where it comes from. So that was Schedule 8 to the SPA headed material contracts. Do you see that?
Yes, I just need to, it is a disclosure letter.
This is an extract from the SPA. This is material contracts.
Okay.
And then if you have a look at we'll take you down to the 6th bullet point. You can see it almost in the middle of your screen there.
Yes, okay, now.
Yeah. Were you aware of the existence of this contract at the time of the SPA? Did you personally know about it?
Yes, I know about it and already gave the copy for the buyer.
And it's right, isn't it? The first installment on that contract. So the contract was for 145,000 Kuwaiti dinars.
How much?
145,000.
Okay.
And the first installment was paid in September of 2018. That's correct, isn't it?
I think that.
Now, the second installment was due the following year, and it was due in April of 2019. That's correct, isn't it?
I think I didn't remember exactly the date, but it should be done at this time.
But it wasn't paid in April 2019.
Yes.
Sorry, it wasn't paid in April 2019. That's correct, isn't it?
Yes. I think it is one installment. They said they can payment and they need to negotiate about to reduce amounts.
Well, I'll come on to that because that didn't happen until later in the year. But by the time that money, that second installment should have been paid, it was not paid. That's correct, isn't it?
Yes, but we are talking now about the company level, not the school level. As I told you from the beginning, we credited the amount in the company account, in the school account.
I understand that. Please, Mr.
Yes.
Rashad, just I'm trying to ask you a series of questions. I understand that. But by the time we get to completion in June, that amount was still quite overdue, wasn't it? It hadn't been paid.
Yes, some amount hadn't been, one installment is not paid.
And in March, just before completion, so in March, there were some reference data counts, what we called reference data counts. Do you remember those? March 2019.
What's the problem in March 19?
They're called reference data counts. They were accounts that were supposed to bring the books and records of the company up to date as of the 31st of March 2019. They were pre-completion accounts. That's correct, yes?
No, again, please, I didn't understand.
In March 2019, so completion of the sale of these two schools, the completion took place on the 26th of June 2019. That's correct, yes?
It's before the completion, yes.
Yeah, so the reference data counts were published or issued on the 31st of March 2019. That's correct, yes?
Can you translate, please, the last sentence, please?
Okay. Yeah, sure. منها في 19 في شهر جون في تاريخ 26 وهناك رقم مرجعي للحسابات الذي كان في نفس العام في شهر مارس. هل هذا كلام صحيح أم لا؟
صحيح. Usually we do the internal report especially for AMAN company, but usually we do our report in August.
Your accounts are usually prepared as of the 31st of August, correct?
No. Our accounting report usually after the end of August, 31 of August.
Yes, 31st of August, the end of August.
Yes.
But for this sale transaction, there were some reference data counts which are referred to in the sale and purchase agreement. They are called reference data counts. Do you remember those?
It's like, I think it's like a management account.
Correct. And they were 31st of March, i.e. they were before completion, 2019.
Yes, before completion.
So when the reference data counts were drawn up, those monies were not yet due because they were due in April. That's correct, isn't it?
I didn't remember the date exactly, but I already write it in my witness statements. Because when I talking about the number and the dates, I have to be in my office and review all the paper and document and the financial statements and the balance sheet and everything to remember the date exactly. But maybe not, maybe right.
Well, I was going to ask you the question, so I'm going to make a statement of fact to you, and then I'm going to ask you a question. That sum of money was not referred to in the reference data counts. My question is this: by the time we get to the 26th of June, which is the completion date, 26th of June 2019, that money had still not been paid. Is that correct?
Some installment, yes, not paid yet.
But the reference data counts were not updated. That is also correct.
Updated, you mean in June?
They were not updated to show that the money had not been received as of the 26th of June.
It's not affected the school account reports. It's affect only, as I told you from the beginning, affect only AJIAL company, not the school.
Well,
school now, from the first day, we don't have any relationship with the school in this contract.
Well, I will come on to talk about that.
Okay.
But so is your evidence that because it had no relevance to the school, there was no need to mention it on completion?
Because all the school management report it was correct, because we do the as usual as every school when we do any contract with the main company, That's why we do the same things with all schools. That's why it's not affects the school management account.
Can I take you to bundle reference page 246, please? Paragraph 88 of your witness statement. So now we're going forward in time to the 8th of October, so post completion 2019. You said it appears that Mr. Dinesh Goyal of Top Business sent a letter to Mr. Ahmed Faraj, who works in my team as the chief accountant, requesting a waiver of 45,000 dinars from the contract value. Can you see that?
Yes, I see that.
So let's have a look at that email. That email is at bundle reference 1302.
Yes, I know that.
You've seen the email. And if we can scroll down to the bottom. So there seems to be a letter attached to this email, which I will bring you to shortly. But it says, this is an email from Mr. Farag, who's in your team, to Mr. Sebastian. And it says, kindly check attach, which I think is the attached letter, for Danish Goyal letter, asking for a discount of 40,000 KD for last year books contract. Can you see that?
Yes, I see that.
And then it says, and his request was not approved by our company.
Yes,
You
it
see
was.
that?
Yes.
It was not approved by our company.
Yes.
So this email attaches a letter, but the email suggests that this issue had come up earlier and that the company had already said, we are not going to approve a discount. Would you agree with that?
Yes, we refuse the discounts.
So you had already seen the letter and you had already refused the discount?
Yes, I see that email and already refused the amount in discount.
So the request for a discount has come earlier than the 8th of October. That's correct, isn't it?
It's coming in October, as mentioned here.
Well, what the email says is that the company has already not approved it.
No, they send the email to Ahmed Farag, our chief accountant. They ask for maybe 40 or 45,000 KD discount. But when Ahmed contacted me, I said to him, it's completely refused. Will not give the discount to this company.
Yeah.
And that's it.
So that refusal took place before the 8th of October because this email refers to the refusal. That's correct, yes?
Yes.
And let's have a look at the letter that was attached to it. I think that's at 1304. Now, the letter that was attached to this email talks about it's a quite a detailed letter explaining the reason for the discount. Is that correct? The letter, if you want to, do you want to read the letter? Are you able to read it, or do you want me to read it to you?
Yeah, I can read it now, but
okay.
Yeah, maybe
tell me.
Okay.
If you read the letter for me, and then tell me when.
Yes, I can read it now. Maybe at this time I get the brief from my team, but anyway, we refuse it. Hello?
Mr. Lovett,
I think he
Mr.
has
Lovett.
to
Oh,
log out and log in again.
okay, thank you.
You can write notes. Can.
And someone from Mr. Graham's teams, please contact him.
My lord, apologies. I think we may have lost Mr. Lovett and all of his team. But, K.S.C.C is here.
With apologies on behalf of the Aiken team, we're just having some IT difficulties which are currently in the process of being resolved. Apologies for any inconvenience caused.
Welcome back, Graham. Everything okay?
Thank you. It is now. I don't know what happened, but apologies, my lord.
Just, Mr. Lovett, just before you resume, you've been mentioning the figure 145,000. I thought it was 125,000. Or am I reading the wrong document?
Sorry, no, you are absolutely correct, my lord. It is 125,000. I think I was confused myself with the 45,000 discount that was requested.
Yeah. Okay. Thank you very much. Just wanted to be sure.
Mr. Rashad, during my absence, have you had chance to review this letter?
Okay, yes.
And if we can scroll down. So this letter is, it's undated and it's not on letterhead. That's correct, isn't it?
Yeah, just now I read it. I'm not remember I read it at this time or not, but I read it now. But I know anyway at this time we refuse any discount for the company.
And can I also just then take you back? Can you scroll down to the bottom of the letter, please? Just go to the very bottom. So do you remember exactly when that first request for a discount was made?
No, I didn't remember the date exactly, but I remember they requested a discount, but we refused it from the beginning.
And can we just go back to the covering email as well, 1302, and scroll down? So at the bottom of that email, can you see this? So this was the email that was finally sent on the 8th. It was forwarded on the 8th of October. At the bottom, it says Ahmed El Hishtawi 13. Is that's the another name that Mr. Farag goes by as well, isn't it?
It's from Ahmed El Shishtawi. Yes, he's the chief accountant for AJIAL.
And he sent that to Mr. Farag. Do you know why that email, it's a question, do you know why that email was sent from the chief accountant's Gmail address to Mr. Farag?
No. Can you go down, please, to see the content for the email?
I think he's forwarding the email that we've just seen, the 8th of October email.
He just forwarded the email coming from the top business to Ahmed to the AMAN company.
Well, that's the question I have for you. It says on there, I wonder if you can help me. It says on the subject heading, it looks like it was a PDF or a note. I'm wondering whether that was the letter that we've just read, the letter from top business. But you can't help me with that. You don't know the answer.
I didn't get your point, Bruce, for this email.
I'm wondering whether this is the same letter that we've just read that was attached to this email and then forwarded on the 8th of October. It's the same date. I just wondered if you could help me. You don't know. You don't know the answer to my question.
He forwarded to them, maybe he forwarded to them at this time to tell them about the renewal, the contract with them. If they try to find another company, if they reject the amount for renewal the contract with the same company. It's a good case.
Now,
Just inform them what happened exactly with the current company. Continue working with them.
And my point is a short one. It's quite unusual, isn't it, for a business email to be sent from a Gmail account?
I don't know why he sent it from Gmail account. Maybe he's outside of the office. He's in navigations. I don't know why he used the Gmail at this time.
Can I ask you a couple of questions about this netting off? I think your evidence and your witness statement is that none of this is material because there was a netting off on completion of the 125,000 KD that was received or a receivable under the contract. That was netted off against the holding company. That's correct, isn't it?
What do you mean netting off, please? Can you translate this sentence, please?
Let me ask you the question another way.
Yes.
Your evidence is that this top business contract and the receivable of 125,000 KD, your evidence is that that was already booked in September 2018 into ICS. That's correct, isn't it?
No, before September 19.
Correct. So in September 2018, it was booked, I think you say, it was all booked as a receivable.
A receivable in AJIAL company, not in school company, not school accounts.
Well, let's have a look at your fourth witness statement, paragraphs 7 and 8, if we can do that.
Page.
Let me just give you the reference.
Page of the bundle.
This is
Where are
which
we
way
from? 339, 339, and 340.
Okay.
don't have 339. So you say that the revenue. So let's start with paragraph 6. They entered into the agreement on the 1st of September for a contract value of 125,000 Kuwaiti dinars. This revenue, so paragraph 7, that revenue was for the benefit of ICS. As such, Mr. Farag has explained to me that AJIAL, in line with its usual accounting practice, debited its intercompany account with 125,000 dinars and credited the full value to ICS.
Yes.
This can be seen from the journal entry. Accordingly, this is paragraph 8. Accordingly, as at September 2018, ICS had received the full benefit of the contract value of the top business agreement. You see that?
Yes, I see that.
Although no cash passed from AJIAL to ICS, ICS had received the benefit of the company liability owed to it by AJIAL.
Yes, we credited in Indian Central School accounts, and we credited the current accounts for AJIAL company. As usual, we do the same things for all contracts.
So you would agree with me, I think, on that basis, that anybody looking at the accounts of ICS would believe that that money had already been credited. That's correct, yes?
Not believe, if he check the accounts and make his due diligence, he will know that it's already credited as in the accounts and debited with AJIAL company. Usually, between the company and the subsidiary, not all the accounts should be cash. Sometimes it's GV between the current accounts.
But as you say in your witness statement, the book entry showed that ICS had received the full benefit of the contract value. That's correct, yes?
Already recorded the full amount in Indian Central School account, yes.
So it's right to say nobody would know that there was a problem with payment of that second payment, would they?
When we recorded in the Indian Central School accounts, we didn't know we will face any problem for the collect amount from the top business.
But someone running numbers on a valuation would run those numbers on the basis that that full 125,000 had been received by ICS. That's correct, yes?
That's correct, because it's already, we have a contract with one of the biggest Indian company for as a books and uniform suppliers.
Okay, thank you. Can we move on? There was a contract. Do you recall that there was a contract between AJIAL and a company called Voltaire General Trading for canteen services?
Yes.
And my understanding, and perhaps you can confirm, but Voltaire provided canteen services to all AJIAL schools. That's correct, isn't it?
Yes.
Are you aware that the defendants were first made aware of this contract in the report of Mr. Fred Brown, in the expert report of Mr. Brown? Did you know that?
Who's Mr. Brown?
He's your expert. He's the expert you've called to give evidence of finance and accounting matters.
Okay.
Were you aware that this contract was not in the data room?
Is the contract is not in the data room?
Correct. Did you know it was not in the data room?
No, I don't know is in data room or not.
Okay.
I didn't read all the data room. As I told you, I have a big team. You provide all the informations from different ways, from legal, from HR, from accountants.
But you would agree with me, would you, that if that contract was disclosed, then the buyers might have been alerted to the fact that this was a contract held at AJIAL. That's correct, yes?
No, again, please.
If this contract was disclosed, it might have alerted the buyers to the fact that this contract was entered into by AJIAL.
Can you translate this sentence, please?
I will move on. I think the fact speaks for it. I think the fact speaks for itself. Sorry, let me move on.
Okay, sure.
But anyway, we disclose that this amounts in the financial statements. It's already very clear. We have a revenue from the canteen for school.
But there's no canteen at the school, though, is there?
You can say there is not the canteen, specific canteen place, but because we are not cooking in the school, sometimes we can sell it in the floor, because sometimes we don't have a specific place, or it's not a cafeteria. It's canteen just with a small place to sell the ready food for the students. It's not allowed in the school in Kuwait to cook any food.
But the food, I will move on. I will move on, Mr. Rashad. But the fact that the food was provided by a third-party company, wasn't it?
The food provided by what?
It was provided by a third-party company. There was no canteen on site.
I don't know there is no canteen or not, but they said, as I heard, there is no space for the canteen. Maybe we didn't call it canteen or cafeteria, but we sell the food in the Indian school before we buy Indian Central School. Since 20 years, they sell the food every year.
Thank you. I'm just going to move on and ask you a couple of questions about compliance with ministry inspections.
Okay.
So you said that the schools were run in compliance with the law, and you say regular checks and inspections were carried out by third parties. That's correct, isn't it?
It's inspector coming from the Ministry of Education. A lot of inspectors coming from different departments.
But you make reference, you exhibit a document in your witness statement from the Fire Safety Inspectorate, and that's at page 722 to 724.
Can you show me, please?
Yeah, I'll bring it up on screen. That's the Arabic.
Yes.
And then there's an English translation behind it.
Yeah. Okay.
But there was another document also which was issued by the Kuwait Fire Service. So you can see, sorry, before I ask this question, this document is issued on the 5th of April 2018. Can you see that?
Yes, I see that.
And this document is exhibited to your witness statement as evidence of compliance with notifications, with ministry requirements, with laws and with regulations. That's correct, yes?
Yeah, once we get this one, that means we are meet the all requirements from the ministry.
And let me show you another one. So there's another notice from the Kuwait Fire Service dated the 12th of December 2017. And I'll bring that up. That is at page 710 and 711. Can you see that document, Mr. Rashad? It says date of approval, 12th of December 2017.
Yes, I see that.
So this document was not in the data room when the
It's
buyers.
See, okay.
This document was not in the data room when the buyers were undertaking their due diligence. So you have to take it from me that it was not in the data room.
Yes, I check with the legal team. he already upload all those, like let's say this file in the data room. It's not required to upload any old license in the data room. You have to upload the latest one, the new one. Once you have the new one, then you have to forget and you have to cancel all the previous license or previous reports. That's why you need to upload 2017 if you have 2018. That's why you have to upload the new one, the latest one.
Well, but the date of expiry was the 11th of December 2022. Can you see that?
I see that.
So it was still a current requirement until 11th of December 2022. So it should have been in the data room, shouldn't it?
No, because we get the latest one. I think they are trying to solve the problem and they are getting the new one in 2018.
But they are different. When you look at those documents, we can look at the previous document. And is this information given to you by your legal team?
Yes, it's by legal team.
Your internal legal team?
Well, yeah, internal legal team.
But if you look at the documents, and I don't want to take your time or the court's time, but you can take it from me that the requirements that are set out in each of those documents are different. One is not a replacement for the other. They are different documents.
Maybe you have some notes from the inspector from ministry, and maybe they are work on it, and they get the new one, and they get the final one in 2018. Maybe after they solve all the problem, or maybe they are asking for another inspection visits, and then they get the newest one. That's why we have to upload the final one.
So your evidence is that this was not in the data room because it had been overtaken by the previous fire license requirement. Is that correct?
As I told you, I'm not uploading this kind of file. But anyway, when I asked them why he didn't upload this in the data room, they said very clear, it is the old one. We have to upload only the final one, the newest one.
Okay, I would suggest to you, Mr. Rashad, that you're mistaken on that, but let's move on. I think you've helped me as much as you can. Let's move on to another topic.
Thank you.
Can we talk about the staff list? So we're talking about assistant teachers and so on. So you say in your witness statement at paragraph 73 that the defendants were provided with staff lists. And that you say in your witness statement, let's have a look at your witness statement if we can. It's document page 243. And it's paragraph 73.
Okay.
So you say, to the best of your knowledge, the Ministry of Education was not compelling you to hire assistant teachers. That's 72. And then you go on to say, in any event, a comprehensive Excel provided to the defendants of staff at the ICS prior to signing the SPA and the various monthly salary reports did not record any teaching assistants at kindergarten levels for the ICS. As such, the defendants were provided with the relevant information that they required during the due diligence process prior to the acquisition of the schools. You see that?
Yes, I see that.
So your evidence is that the defendants were provided with staff lists. And because those staff lists did not mention any kindergarten teachers, that should have alerted the defendants to the fact that there was something missing. That's correct, isn't it? That's what this statement says.
No, I already provide with them for them all the salary sheets with the historical information from maybe three years back, and already Mr. Keo He have a Canadian school in Kuwait, and he's very aware about all the position requirement in the school. And he review all the salary sheets, and he asked me a lot of times about some position and some names. And they are aware we have what we have and what we don't have in the school.
Well, let's have a look at let's have a look at page 716 to 721. So that's the Arabic. If it's okay with you, if we could look at the English, I'm afraid most of us are English speakers. Could we look at the translation? So
yes, okay.
And so on that page, you can see at the bottom it says there are no female teaching assistants in all education stages. Can you see that?
Yes, I see that, but I need to see the original paper, please.
Okay, we'll show you the Arabic. Just bear with me.
Yes. Yes, this is it's writing by the inspector hands. It's not the official letter coming from the Ministry of Education. It's like
Well,
it's normal visits, and he can write whatever he wants, and we can do according to rules and according to law.
Well, this is a matter that we're going to discuss later in the trial, but I'm just asking you about this letter, and I'm asking you about the disclosure that you say was made to the buyers about having teaching assistants. So if we can go back to the English translation on page 720. We can scroll down. It says there, sorry, so page 720. That's it. So at the bottom there, if we can stop there. There's an asterisk there. Can you see further? This is the inspector. It says further, I stressed necessity of doing the following. And then he goes, there's a number of things that he lists here.
Yes.
And then over the page, that list continues, page 721. And then he says, 2/3 of the way down that section, provision of female teaching assistants for kindergarten classes. Can you see that?
Yeah, I see this. I read it all before.
And so there was an inspection report. That's correct, isn't it? There was an inspection report, which this one was dated the 27th of March 2018, which required female teaching assistants for kindergarten classes. That's
Yes.
correct, yes?
As I told you, it is internal visits in the school. This kind of letter is not coming to the head office because, as I said to you, this is internal letters and internal visits. He can write by his hands his notes, and we can do after we receive the official letter from ministry with the deadline to finish all the requirements. This is any inspector this kind of letter we didn't receive in the head office. That's why we didn't do it in the data room, because it's not required, because it's internal and it's not the final notifications.
So that was, so I think you've answered my question. Thank you. So my question to you is, why was it not in the data room? And your answer is not required. It was a locally kept document. Is that correct?
No, I think he write this notification in the visit books inside the school. It's keeping direct with the principal inside the school, not with the head office. We didn't receive this kind of visits. Maybe when we are talking now, we have a different inspections in the schools.
Okay.
School from different departments. That's why we didn't receive all this visit to the head office.
So let's go
Especially
back.
letters, sorry, especially the letters coming direct from Minister of Education to the owner for the school.
So let's go back to page 243 in your witness statement, paragraph 73. So all you say here, I mean, you make a point of dealing with kindergarten assistants, teaching assistants. This is the purpose of this paragraph. But all you say here is that you gave them a list of teaching staff, and with that list, they were able to work out that some staff must have been missing. That's what you say here, isn't it?
Yes.
And now you've said that they could not have worked it out because that document was not in the data room, and they would not have known at that time that kindergarten staff were required. That's correct, isn't it?
No, it's not required. As I said, if you want to add it, as I told you, it's option to add a teacher assistant or not. We have a lot of schools. We have some schools we have teacher assistant, and some school we don't have teacher assistant, especially for Pakistan and Indian school. It's not international school to require to put teacher assistants. That's why if he want to put teacher assistants, it's optional for him, and he can move from the beginning. We have teacher assistant not in the school.
Okay, Mr. Rashad, I'm going to move on. I'm going to say to you that that's not an option. It was a requirement from the ministry, and it's something that wasn't disclosed. I'm going to move on to another subject.
I think, Mr. Lovett, if you're putting up, expressing a view on something, you must allow the witness to deal with it. Did you want to say anything, Mr. Rashad?
Yes, I think it's not required from the ministry. If required, he can send the official letter from the ministry said the teacher assistant is required for the Indian school in Kuwait. It's not required. It's required only for British and American system in Kuwait. Indian school, Pakistani school, some Arab school, it's not required to put teacher assistants in the school.
I'm going to move on, Mr. Rashad, to a new subject.
Thank you.
This is, it's still on the subject of staff. And I'm going to ask you a little bit about the staffing arrangements at the school.
Excuse me.
My lord, am I able to continue?
Yes. I'll mute myself.
My lord, this might be a convenient moment, in fact, because it's 16:39 where I am, and I'm just about to start a little bit of a new topic. Should we have our short breaks 5 minutes earlier than anticipated, but it might be helpful to you.
Yeah, let's have 10 minutes now.
Thank you, my lord.
10-minute break. Thank you.
10 minutes, thank you.
We'll take it.
Yeah, we have a short break. So if you want to.
Molly, if you're still muted, you're not muted.
Yeah.
Molly's, you of course can't talk to Mr. Rashad during the break.
Sorry, Hugh, I couldn't hear you there. So
I was reminding you that Mr. Rashad is under oath, therefore you shouldn't be speaking to him about the case.
yes, of course. No, I was just answering whether he may go to the bathroom.
Of course he may, of course.
Yeah, we'll finish at about 6.
Would your lordship, if I just prompted Mr. Lovett and his team that your lordship is back in court?
Great, thank you. Yes, Mr. Governor, sorry to interrupt the flow before the break with my coughing.
No, not at all, my lord. You probably did me something of a favour, actually. So I'm going to start, Mr. Rashad, on a related topic, which relates to staffing. I'm going to give you some names, and I'm going to ask you if you're familiar with these individuals.
Okay.
The first one is Kani Krishnan.
No, if you want to talk about the Indian school staff, I'm not remember exactly the name. It was since 5 years, and it's more than 300 teachers inside the school. And I have, as I explained to you, I have 20 schools around the Kuwait and outside of Kuwait. I didn't remember the name. I can go back to the lists and we can know the positions and can ask your principal about his positions. But I didn't remember the name. If I have to go back to the record.
So if I ask you questions about your personal knowledge of these individuals, is your answer that you don't know them, but you could identify them from a staff list? Is that correct?
No, sometimes the positions is different in the staff list, but we can ask the leaders, the principal, the assistant principal, the accountant for the school. But by name, sometimes I remember some employment inside the school, maybe some senior name, and sometimes not.
Well, but let's just go through the names. If you could answer yes or no if you know them by name, and then I think we can finish this relatively quickly.
I think by name you can ask the school principal, not me, and the CFO for the group, including 20 schools, as I explained to you.
But you give evidence about these people's roles. I thought perhaps you might know them, but you're telling me you do not know them.
No, I'm not know him personally or by name, but I go back to the records and check with the team. I know what he is doing exactly in the school. But if you ask me about the positions, not the name, I can explain to you about how many positions we have in the school and what they are doing inside the school.
Let's talk about, let's look at paragraphs 75 and 76 of your witness statement, your second witness statement.
Okay.
I think that's at page 244.
Yes.
So these are the vice principals. So we've moved on from the kindergarten staff, but now we're talking about vice principals. And again, I think this is similar to your position for the kindergarten staff. At paragraph 75, you say ICS had a number of vice principals at the school, and the defendants had all the relevant information on this in light of the document shared with them in the virtual data room. Do you see that?
Yes, I see that.
And then you say there are staff lists that disclose vice principals. They are at pages 731. If we can have a look at 731.
Yes.
We're just going to bring it on the screen, Mr. Rashad. So just bear with me.
Yes.
Okay. So if you can see, can you read this? It's the print is quite small, but can you see it?
What's the including number, please?
Sorry, the document number is 731.
Yeah, I know the document. What you want exactly?
Well, sorry, my question to you, you would agree with me, wouldn't you, that the job and title there, when you have a look down, it says principal, cashier, helper, electrician, driver. There is no title of vice principal, is there?
Yes, because sometimes you have some teachers and they give them like another duty, like a vice principal, like a supervisor, like a head of departments. It's not mentioned in the HR system, but I think they get another salary sheets from the principal, including all actual positions inside the school and the actual duty for each one inside the school. Sometimes you have teacher, but he work as a head of department. Sometimes you have head of department, but he work as a head of department plus vice principal.
But my question to you, you could not tell that for anything. You could not tell that by looking at this document. You must agree with that, yes?
It's not only this document we upload in the data room. We upload data room 3 years salary sheets, including some report from principal, including all positions inside the school. It's according to their requests.
How are how are you so certain that all these documents were in the data room, Mr. Rashad?
Because I review again when we prepare my witness statements, I review some documents in the data room, and I review and really I share with our lawyer about some reports coming from the principal, including the actual positions inside the school.
Let's have a look at document 1127.
Okay, this is a salary payment.
Got that, Freddie?
Yeah.
I haven't got it yet. Oh, here we go. So again, if you look down at this document, so these are monthly. This is a monthly salary report, but it doesn't give the title. So again, you would not see vice principal on this document, would you?
Yes, as explained to you, this is a monthly payments. It's a salary payment. It's not including the title and some other report as you show up. It's including the title and some internal report from the schools. They are show up the internal duty for each one inside the school.
So you say that.
Sorry, sometimes my position inside the school as a teacher, but inside the school I work as a head of department or as a vice principal, but I'm waiting to get the approval from Ministry of Education. And they send some approval from Ministry of Education for different name inside the school. They have already approval from Ministry as a vice principal for Indian Central School.
But your evidence was in your witness statement that the defendants had all the relevant information, including a list of staff and job roles. That's correct, isn't it? That's what you say in your witness statement.
Yes, and I already give them the approval, the ministry approval from each
And
one.
Sorry, please finish. Did you attach any document to your witness statement that identifies any individual as a vice principal?
Yes, I remember I attached one evidence from coming from the school. It's including the position for each one inside the school. And already I attached the approval from ministry for maybe 4 or 5. It's as a vice principal working inside the school.
Can I tell you that the documents that you referred to at paragraph 76 of your witness statement are the two documents that we've just seen. The two documents that I've just called up are the documents that you say identified vice principals. That's what you say in your witness statement. But that's not correct. That's not correct, is it?
No, again, can you show me the attachment, please?
Well, this is one of them, the one we've got up on the screen. You say that it clearly shows that there were a number of vice principals at the school. Now, this is the document that you're relying on in your witness statement. Can you show me where it says vice principal on this document?
I don't have the attachment now in my hands. It's already with you, but already I attached it before.
Well, this is it. This is it on the screen. I'm showing it to you on the screen.
Okay, this is the salary payment.
So it's
excuse me, I attached the ministry approval for the vice principal inside the school. 3 or 4 vice principals inside the school.
Well, we'll come on to the ministry document, but the two documents that I've just put up, this one and document 731, which is the document before, neither of those documents identify specifically a vice principal, do they?
No, this document explains how many employees we have and how much the salary for each one. And another one, what's the title positions inside the HR system. But we have another report and another attachments, including the actual position inside the school. And already they hand over all the files for all teacher inside the school by hand. They are bring the card to the listed to the head office, and they carry all the files for all employment inside the school, both the school, not only one school. That's why they are right from the beginning.
But these are the two documents you rely on in your witness statement. I'm just showing them to you, but you would have to agree with me that they don't say what you say they say.
No, if you go back again to ministry attachment, you will find the definition for each position.
731. I think, Mr. Rashad, I can take you back to the previous document, but this is the document. These are the two documents you refer in your witness statement.
No, there is another attachment also showing here. The from ministry report, from ministry approval, from Ministry of Education.
Well, let's move on, Mr. Rashad.
Thank you.
I now want to talk to you a little bit about your maintenance team.
Yes.
Now, you say in your second witness statement, paragraph 113, that's document number 251. I'll just read it through to you if I may. Furthermore, prior to signing the SPA and the completion date of 26 June 2019, I recall I had several discussions with the defendant's representatives at the time, including Mr. K.O. Matthew and Mr. Al Falah. Once again, as is clear from the financial information provided to the defendants during the due diligence phase of the transaction, and in response to queries raised in our respective meetings, I explained that the AJIAL group, had their own maintenance team of approximately 10 staff that was contracted to provide services to all of the schools managed and owned by AJIAL group at the time. The group maintenance team would, where necessary and required, attend to larger maintenance tasks such as air conditioning, maintenance tasks or electric repairs as allocated to it by the school management team.
Yes.
Now, you also go on to say, so you said you had that discussion with Mr. K.O. Matthew and Mr. Al Falah.
Yeah, we'll have a long discussion with both of them in my office.
And you discussed a lot of things then, did you, in that discussion in your office?
Yes, they came sometimes in my office before the completion and asked a lot of things and how we operate the school and how we manage the school, and they asked for a lot of assistance, and already explained to them a lot about the operation and how we deal with the staff and how we manage the group. It's a lot of discussion with Ahmed and with Mr. K. Matthew. And K exactly asked about the maintenance. And already I told him we have a small team, and I already explained to him you have to make your specific team in DS. And he told me, Mahmoud, don't care about that. I can deal with that. And already I explained to him also about the accounting team. If you want to talk about accounting, and already told him if you want somebody from my team here to transfer to your residence, I am ready to help you. Already I told him we have Mr. Shahzad, he's the company accountant. I can move his residence due to help you for DS, but he told me no, thank you. I have my team. That's why I don't need anyone from your team to move to my company. This exactly happened between me and Mr. Kuman.
Well, but the costs associated with that management team were not allocated to ICS, were they?
Because this team is working for different schools. Maybe sometimes he work See, in Indian Central School, you have specific team inside the school. You work for emergency maintenance or any small maintenance, and that's why no need any help from the team in the company level. Sometimes the team in the company level help only in the major things, but we allocated all the materials and all the spare parts direct to the school accounts.
So what you're saying is that the schools had a minor maintenance team on site, but anything that was major was done by the central maintenance team. That's correct, yes?
Sometimes by our team, and sometimes we bring the maintenance company and we allocate the expenses direct to the school.
And you did not charge the maintenance team to the school. You charged the spares and the equipment, but you did not charge the team. That's right, isn't it?
Equipment and spare part, because usually we didn't use the company maintenance team to Indian Central School, because we have a lot of like maintenance team inside the school, and we can ask the principal or the current principal about that. That's why it's not going direct or always to Indian Central School. That's why we didn't allocate this small amounts of expenses in the maintenance to the school accounts. And already we do the same things for all schools, not only for Indian Central Schools.
Well, so but your evidence is that they were allocated to provide or contracted to provide services to all of the schools managed by the AJIAL group. That's correct, yeah?
What do you mean contract?
Well, I'm asking you, this is your evidence. Your witness statement says, I explained that the AJIAL group had their own maintenance team of approximately 10 staff that was contracted to provide services to all of the schools managed and owned by AJIAL group at the time.
Yes.
But the costs of those staff were not passed to the schools. That's correct.
That's correct, because it's not work only for specific school. It's work sometimes for 4, 5, or 6 schools at the same time.
But that was not disclosed in the disclosure letter.
I already explained to Mr. Matthew and Mr. Ahmed Falah about that, and they already know, and he already have a school in Kuwait, and he know how we manage the school and how he managed also his school, and already disclosed the number of staff with the positions, and he know how many staff we have and how many maintenance team we have inside the school, and it's enough or not. We already discussed and we already talk about long time about these things with
But
Mr. K.
But it was not disclosed in the disclosure letter. That's correct, yes?
I didn't read all the disclosure letter, but maybe we already explained to him and we disclosed the salary sheets and all the salary title and position inside this. That's why it's disclosed. It's very clear.
Let me move on.
Sorry, anyone have experience like Mr. K in education, because we already have a Canadian school in Kuwait. Once he just a quick look for the salary sheets, he will understand what we have and what we don't have.
So are you telling me that during a due diligence process, if you're dealing with somebody that has experience of a business, you don't have to disclose it because they already know it? Is that right?
No, we have disclosed every paper we have and everything we have, and according to his experience, he will understand what we have and what we will have and what is required and what's not required.
And what disclosure did you make? What paper disclosure did you make about the maintenance?
All the salary sheet and position inside the school.
So that's your disclosure, the salary sheet and positions.
This only we are talking about the paper. This is the salary sheets and salary position and HR reports and the school, all employment file already disclosed to him, and all approval from Minister of Education for each one inside the school. All of this disclosed already to Mr. Kio and Mr. Ahmed. And
but those salaries, sorry to interrupt, Mr. Rashad, those salary sheets do not include AJIAL group staff. That's correct, yes?
It's include the only DAS staff.
Okay.
And it's very clear how many maintenance staff they have.
Can we talk about software licenses?
Okay.
Let's have another look at your witness statement at paragraph 155 on page 262, please.
Okay.
So you said that you provided various clarifications to the defendants in respect of the defendant's RFI. In respect of software licenses, I note AJIAL had provided the following clarifications to the defendant's inquiries. I'm not sure. Can we expand that without ruining the?
What?
Okay, so sorry, this is paragraph 155 of your witness statement.
Okay.
So the standalone document, I think this is an extract from a document that's at page 754. So maybe it's easier to have a look at the original rather than a screen grab. Oh. So we're trying to get the relevant section on the screen. Freddie, can we come down a bit? So can you see the screen, Mr. Rashad?
Yes, yes.
So we're talking about fee collection software being GeoSoft.
You're talking about Indian school or Pakistan school?
Well, sorry, let's start with the Indian school first. The fee collection software is GeoSoft.
Okay.
And then the counting system is Unisoft.
GeoSoft, yes.
And then number 2, it says accounting system is Unisoft.
Unisoft is account system, yes.
Yeah. And where are those accounting systems used? Are they used in the school or in head office?
See, it's two schools. All schools they have to use. Some schools they use two kind of system. One, like we can call it collection system. It's like a student name and how much the receivable and how much they have to pay and tuition fees and everything. And another one is account system. His name is Unisoft. He was inside the school also, and we have connection with the same system in the head office or the senior accountant to review the daily collection and the daily report and daily operation inside the school. And it's not our system; it's the rental system from the local market.
But there's nothing on this disclosure here which says we cannot transfer the licenses to you. There's nothing there, is there?
Because already explained, we have the system. We can transfer the license because it's rental license. It's all school in Kuwait that have the rental license from the local market to operate the accounting system.
When did you explain that, Mr. Rashad?
Explain like what?
Well, you said you've already explained that these licenses are commercial licenses, but
yes,
where sorry to interrupt. Can I just finish asking the question?
Okay, sorry.
When did you explain to the buyers that the licenses could not be transferred to the Indian school or the Pakistani school? When did you do that?
Already we give them the copy from the system contract. It's a contract. It's yearly. GeoSoft we pay only yearly. It's 150 KD for to use the system. 150 KD is less than $500 yearly to use the system. It's not our system. It's local market system. We use it every year like another school in Kuwait use the local market system and its rental system. We don't have our own system except the Pakistani school for the collection system only.
And are you aware that in the SPA you undertook to transfer to the schools all of these licenses and all of the software as part of the sale and purchase? Are you aware of that?
If you own any system or any license, we have to transfer to them, but we didn't own this one. It's rental system.
Okay, but you went and you disclosed the fact you did not own it.
Yeah, they are aware that this Unisoft system, there's a lot of company and schools where use the same system. It's related to a Kuwaiti company. They are working in the market since more than 25 years now.
But it's right, Mr. Rashad. If you have a license, by definition, you don't own it. You have a license. That's correct, isn't it?
We don't have a license. We have a contract to use the system. That's what we have, and we need to give them the copy of this contract.
Can we turn to the accounting function, please?
Sorry?
Can we turn to talk about the accounting function in a bit more detail?
Okay.
So your evidence, as I understand it, and let's have a look at paragraphs 102 and 103 of your witness statement. Page 248.
Thank you. Yeah.
So you say at 102 prior to, and this is relevant to the salary transfer. I'm not talking about salary transfer. I just want to talk about the accounting function generally. In paragraph 102, you say prior to signing the SPA, I recall I had several conversations with the defendant's representatives at the time where I confirmed that AJIAL made use of a centralized accounting system for all of its schools, and that accordingly payments were made from the bank accounts of AJIAL and then allocated as relevant to the particular school, in this case, PES or ICS. So you had a centralized accounting system, that's correct, yes?
It's the same system inside the school, like, Unisoft system. It's the same system. We have connection in the head office, but when we transfer the salary, it's transferred in the online bank.
Sorry, Mr. Rashad, my question was a very simple one, and I was just reading back your witness statement. I confirmed that AJIAL made use of a centralized accounting system. So my question to you was, is that correct? You had a central accounting system at AJIAL?
As I explained to you, it's the same system inside the school. It's Unisoft system. This is the only account system what we have. We use it in the school, and we have the connection in the head office. We are following every day what we happen inside the school.
How did you allocate the costs of that function?
Which functions?
Accounting function. We're talking about accounts at the moment.
You mean for the rent from the program, from the accounting program, or what?
Well, I'm just talking about there's a centralized accounting function which you talk about in paragraph 102 of your witness statement, and I'm asking you whether the costs of that centralized accounting function were allocated to the schools in the group, or whether the costs of that function were retained at holding level.
We have chief accountants and 2 accountants work in the head office. They are managed and they control the schools under a AJIAL company, and they are reviewing the transactions and doing a lot of accounting services for all schools.
And then you go on to say at paragraph 103, you said the defendants were at all times aware of this state of affairs prior to the acquisition. So you're telling me that they knew about the centralized accounting function?
They are aware about that. And as explained to you from the beginning, I said with Mr. Keo, I explained to him how I manage the system and how I manage the school and how many teams I have in head office. And I told him we have this guy, his name is Shahzad, he's Pakistani accountant. He's the supervisor for both school, Indian and Pakistani school. And if you want him to move from AJIAL company to Dar es Salaam, to DS, or to your new company, I can move to him to help you to manage and to control the accounting. But he told me, thank you, I have my own team. And he already sent his team, his full team, to our head office to sit with my team to explain to them about all the system and operation and accounting and to hand over all the information.
Mr. Rashad, can we look at paragraph 131, please, on page 257?
131?
Paragraph 131.
Okay.
So now you're talking about the local accounts. You're talking about individuals who are employed at the schools. These individuals would prepare the relevant schools' accounts and input these into the centralized accounting system. They required minimal oversight from my accounting team at AJIAL. As such, these individuals ran a self-standing account system in respect of each of the schools, which were fully functional and met the needs of the schools at the time.
Yes.
So the impression you're giving here is that the schools had a self-sufficient accounting function. Yes?
Yes. Yes. For example, Indian Central School, they have 2 persons in the accounting team. They have cashier. Her name was Prasanna. She worked in the school since I think more than 10 years. And Jomun, he was a school accountant. He do the everything related to the school accountant, not the collections. I'm talking about the accounting system, and he do everything related to the school. My team in AJIAL, as an owner, it's just to review and quality assurance and to make sure everything is working according to the standard. And we manage we are just pull up the deposits and pull up the work. That's it. It's, I think maybe one only in the head office he review the accounting in the Dar es Salaam. Also PS they have 2 accountants in the school. Abir, I think, and Abdul Khalid. Abir, she work as a school cashier, and Abdul Khalid work as a school accountant. He do everything related to account system inside the school. And I think this was fair enough for the school.
Mr. Matthews says that they were cashiers. He said they are not proper accountants.
You have the cashier and the accountant, and I think I heard after that he terminates his residence and he hired, I think, another accountant for the school. Jomun and Prasanna. Inside for Indian Central School, and we have 2 for PS School, Abir and Abdul Khalid. I remember their name because they are part of my team.
Can we talk about the IT systems at the school?
We can talk about IT. Okay.
Let's have a look at paragraph 142 of your second witness statement.
Okay.
Sorry, that's my lord, that's at page 259.
257, I think.
I have it as 259, but it is 259. Paragraph 142, Mr. Rashad.
42, okay. I think 152. Okay.
So you say during the time the company was under the management and control of AJIAL, each of the schools had IT staff assigned to it the costs of which were properly allocated. What do you mean by properly allocated?
But the work, it's part from the salary sheet for the school.
But when you say they're under the management and control of AJIAL, do you mean that the costs were allocated to the schools?
Because once you work inside the school daily, inside the school, that means it's already allocated to the school expenses direct, not in the head office.
But you say that the company was under the management and control of AJIAL. Each of the schools had IT staff assigned to them. So they were assigned from AJIAL?
What do you mean sign?
It's your words. You say they were assigned to each of the schools, that they had staff assigned to them. Each of the schools had IT staff assigned.
Yeah, yes, it's already working specifically for Indian Central School, and you have a specific team for PS school. And they work daily, they have the daily work inside the school, and already allocated the expenses direct with the school, with the salary expenses every month.
So is your evidence that there was no central IT function?
We have an IT manager for in the group level, not in a general level, in the group level.
Is that Maha Al-Tamimi?
Yeah, Maha Al-Tamimi, yes.
So she was an IT manager, is that correct?
It's IT manager for Algeria Holding Group.
And she would help at the schools when required?
When required, but it's because specific Indian Central School, they're working since 20 years back. That's why I think there is no need a lot of help from Maha. Because Maha, she work specific for in Algeria Holding Group level.
But she's what I would call an IT manager, so she would help. She was a skilled IT professional, is that correct?
Yes, she is IT manager for Algeria Holding Group. She is managed, as I told you, 20 schools also under her positions.
Let me talk a little bit. Let me talk a little bit about marketing.
Okay.
Your evidence is that AJIAL does not undertake any marketing activity at all. Is that correct?
Correct. It's specific for Indian and Pakistani school. This is what I mean, not for other schools.
So are you saying there is no LinkedIn page, there is no social media?
I think AJS, they have their own social media like Facebook page, and already, and I think Instagram page. It's managed by IT person inside the school. It was under the principal for the school direct, not under Algeria Group. And we already allocate all the expenses direct from the school.
So AJIAL does no marketing at all?
Nothing.
Have you heard of a company called teacherhorizons.com?
No.
Let me turn to the laboratory assistants, if I can.
Sorry?
Talking about laboratory assistants now.
Okay.
If we could turn to paragraph 70 at page 243 of your witness statement.
Page number
243, please.
Okay.
So we're now talking about the laboratory assistants.
Okay.
So then you refer to the salary reports, which I think we've seen. We've certainly seen examples of salary reports. And you say what you normally say, which is that the defendants had all of the relevant information required to ascertain the staff of PES prior to the acquisition.
Yes.
I'm not aware of any particular individual with the designation of laboratory assistant at this time. However, as indicated above, I do not recall that we ever faced any issues from the MOE. In the absence of a designated laboratory assistant, I would have expected other staff members to assist as and when necessary. I'm also aware that the required qualification for a laboratory assistant was relatively strict. Therefore, it would take time to find an appropriate individual to be appointed in this role.
Yes.
It's right, though, Mr. Rashad, isn't it? If the qualifications for a lab assistant, a laboratory assistant, are relatively strict, how could you expect other staff members to assist as and when necessary?
It's related to the school principal. She can assign someone, can have an experience in this position as a science teacher. He can help in as a lab technicians. Then she can use some teacher or science teacher to work as a lab technicians. I know it's required, as I told you before, teacher assistant not required, but lab technician is required by ministry. But sometimes you have some missing position inside the school, and we are looking for the market or outside of the Kuwait to hire someone from internal or external from outside of Kuwait.
And how would you do that? How would you find somebody outside of Kuwait?
Sorry?
How would you find somebody outside of Kuwait?
I think HR, they are trying to find someone from local markets to work in these positions. You are talking now about BAS. The problem with BAS exactly because they have some we have some problem in Kuwait to hire someone from Pakistan. It's not easy to bring someone from outside of Kuwait to BS school because it's not allowed to make any visa for Pakistan citizen in Kuwait.
I'm sorry, I thought your answer to my previous question is you were looking outside of Kuwait for a lab assistant.
Yeah, we are looking inside and outside also.
And how would you look outside?
Yes, sometimes you can get some exceptions for ministry section for educational sector, but it's not easy to get this approval. But all of the things it's related to HR. They are trying hard to close this or to find this position, but I think it's not easy. And also sometimes we can work without this position inside the school.
Can we have a look at document number 2188, please? You can see, so this is an extract from 4 of 2008. So this is a requirement, this is a ministry requirement for a science technician.
Yes, I said now in the beginning, it's required for ministry to put the lab technician. And library also. I said from the beginning it's required. I didn't say it's not required, it's required in notice. But it's not easy to get these positions, especially in Pakistan school.
And did you disclose to the buyers when they bought the school that there was no lab technician or no lab technicians?
No, we disclosed the salary position, the salary sheet, and the position and the title for each one inside the school, from the principal to the school guard and the security also. That's why we disclose all the positions inside the school.
Thank you. I'd just like to ask you a couple of questions about something which is probably more familiar to you and less familiar to me, which is accounting practice. When you draw up, or when AJIAL draws up financial statements, who signs off on them?
Sorry?
Who will sign off on financial statements drawn up by AJIAL?
Or sign the financial statements?
Yeah, who will approve them? Who will sign off on them as approved?
It's prepared firstly from the accountant and then reviewed by the senior accountant and then chief accountant. And then we are bring the external audits, RSM, they came for maybe 4 or 5 months to review the all transaction inside the company. And after that, it's coming to me the draft. I review the draft and I sign it from the chairman.
So the chairman will sign off?
It's according to law, the chairman have to sign the statement and send it to Ministry of Economic.
And is that done? Does the chairman sign with the approval of the board? Is there a board meeting?
Yes, usually we sign from him, and after that we're making the board meeting to review the statements and take the decision or anything like that.
So there is quite some formality to approving the financial statements and the accounts then, is that correct?
It is as usual, we do the same things. I already explain what we are doing inside the company.
Did the defendants have any role at all in managing the school prior to closing on the 26th of June 2019?
Sorry?
Did the defendants have any role at all in managing the school prior to closing on the 26th of June 2019? Who managed the school prior to closing?
Who managed the school?
Who managed the schools prior to closing?
Until closing, AJIAL managed the school until closing. AJIAL company.
Okay, thank you.
Go.
I have a quick question, or two more quick points that I'd like to ask you about. My lord, I could benefit from 5 minutes or so just to collect my thoughts. I'm probably doing better on cross-examination than I thought I might, and I'd just like to check my notes just to see if I could curtail things. Could you indulge me for 5 minutes?
Yes, of course. We'll take a 5-minute break.
Thank you very much.
Thank you.
Thank you, my lord.
Thank you. We'll just... Yes, Mr. Robert.
Thank you. If I could take you, Mr. Rashad, to document number 69, which is an extract from the sale and purchase agreement. If we could zoom in a little bit on that. Mr. Rashad, this is an extract from the sale and purchase agreement, and this is under Part B, which is general warranties. And this is the last part of Schedule 5, which refers to working capital. And it says there is sufficient cash in the company's bank accounts as of the completion date, which is the 26th of June 2019, to cover the working capital amount. Do you see that?
Yes, I see that.
My question to you is, did you comply with that obligation under the SPA?
What do you mean, please?
Well, it requires the company to have sufficient cash in the bank account as of the completion date to cover the working capital amount. Did you, as sellers, comply with that obligation?
هل التزمت بهذا البند؟
ممكن ترجمة أصلا.
هل التزمت بهذا البند؟
بالتأكيد التزمنا بالبند.
Certainly I complied with this article.
And if we can turn now to page 25. Can you see there the definition of working capital amount?
Yes.
And it says working capital amount means an amount sufficient to fund all expenses of the company through the 31st of August 2019, including but not limited to monthly expenses necessary to cover the construction costs of 2 new school buildings and a trapped cash reserve of 25,000 Kuwaiti dinars. Can you see that?
Yes, I see that.
So if you were in compliance with the working capital requirement up until the date of completion, presumably that included enough money to cover the monthly expenses and the monthly salaries of staff up to the 26th of June. That's correct, isn't it?
Yes, after when we in the completion date in June, I think the receivable from the first term in Indian and Pakistani school, it was more than $400,000 Kuwaiti dinar. That's why it was enough to cover all expenses, including the summer salary and all maintenance during the summer for the school. At this time, we have 2 options. The first option, to force the parents to pay in April term. April term starting in 1st of April till end of August. This full term we didn't collect from the parents, and it's required to pay in advance in April. But because we can't force the parent to pay, that's why we pay in advance from AJIAL accounts the salary for April, May, June, July, August. And that's why we ask AMAN to pay back to us the receivable related to this period for the first term.
Well, completion didn't take place until the 26th of June 2019, did it?
Yes. But the working capital, it means cash and receivable, not only cash.
Can we have another look, or sorry, can we take a look at the fixed asset register at page 769, please? Now, I think this is a document, Mr. Rashad, that an earlier version of this you rely on in order to explain about the depreciation of buildings. Is that correct?
Sorry?
You rely on the same document, but it's dated 2015. But this is an extract from what I believe is called a fixed asset register. Is that correct?
Yes, it's fixed asset report, depreciation report. This is from my team, AJIAL.
And on the top line there, there's a figure of 520,492.75 Kuwaiti dinars. That's correct, yeah?
Yes, it's 2013, I think.
And this is an extract from 31st of August 2018. But it doesn't really matter about the date. I just want to cover off a couple of principal points with you. As I understand your evidence, that top figure is a valuation for the ICS building, the yellow building. Is that correct?
Oh, it's not the evaluation, it's the book value in not evaluations.
Well, it's a book value, but it's for the ICS building, which you described as the yellow building.
Yes, I think.
Have you seen any costs relating to the yellow building? Have you seen any documents that evidence how much that building cost to build?
Did you mean when we buy a GR company?
When you acquired your interest in, remind me, which date was it? It was in 2014?
I'm not remember exactly what happened. It was since 10 years ago.
But to the best of your recollection, do you remember seeing any documents that supported a number that gave a valuation of the building assets that you acquired?
As I explained to you, it's more than 10 years. That's why I not remember exactly what happened at this time. When we acquire AJIAL, I don't remember what happened. We do our due diligence by me and my team. It's not only me. We have a big team to make this acquisition and due diligence. That's why I didn't remember what happened since 10 years ago.
So your answer is you cannot remember where that figure comes from?
Yeah, we have my team. They make the due diligence for AJIAL and for Indian school. It's a big acquisition. It's not a small acquisition. It was a 4 schools.
But presumably, I'm sorry to interrupt, but presumably if you had the underlying documents relating to that building, you would have disclosed them in the virtual data room. Is that correct?
Disclosed in about the numbers since 10 years ago?
The documents relating to the yellow building, if you had them in your possession, you would have disclosed them in the virtual data room. Is that correct?
We disclosed the financial positions and the depreciation reports from each building inside the school, and we already disclosed by my team to them, and already make the actual visits for the school maybe 2-3 times.
And did you disclose any of the construction related documents that showed the cost of construction?
As I told you, we have a big team, and we have so many people that disclose a different paper, like legal department, HR department, facility. We have a big team who disclose a lot of letters, but I'm sure we already disclosed the financial positions and financial costs and the value for each building inside the locations.
So if you have the value for each building, this number, I'm trying to understand this number at the top, this 520,000 number. Is that a consolidated value for all of the buildings in the school?
As I told you, I'm not remember from 2013. It's 10 years ago, but I'm sure maybe for I don't know, it's for see the other school, other building, it's all related to Ministry of Education. It's rental building. It's not owned by us. It's not built by us. The other building, what we already demolished, it's related to Ministry of Education. It's rental building.
But those buildings were demolished, yes?
Demolished in before completions.
When you say demolished before completion, you mean demolished when?
Demolished, and we built a new building in the same locations.
When exactly were those buildings demolished?
When exactly? I think maybe 2 years before the completions.
So what year would that be, Mr. Rashad?
See, it's a long process. We already start, I think, 2016 or 2017 to start to renew the old building inside the school campus. That's why we have put a big plan to remove the old building related to Ministry of Education It was one floor. It's a K.S.C.P building. We are trying to remove this building. It's since more than 25 years. It's one floor K.S.C.P. It's with the small AC. It's very old. That's why we are trying to remove it, and we are trying to renovate the old building inside the campus. That's why it was only 2 buildings with 1 floor. We established 4 buildings. One for Indian Center School and 1 for Pakistani School, and two new buildings. It was under construction when we signed the SPA with AMAN company. That's why they are very interested to buy Dar es Salaam, because they have 2 current school and 2 schools plus 2 school under construction.
Can we just move this document slightly to the left so we can see the entry on the left-hand side? You see down the left-hand side, there's an SR number. And then in the 4th column, there's a date, correct?
Which one, please?
So we're looking at the same document. The 4th column, it says date. Can you see that?
The first
And the 4th column number 4.
It's 9 January 2013.
العمود الرابع.
So the first date is the 31st of August 2013. It's American dates. Can you see that? In the column number 4, it says date. I'm only asking you if you can see it.
Yes. Starting from 31 of August 2013.
Well, it's 2013 on my document. You have the right document number? The document on screen, Mr. Rashad, it says 31st of August 2013, yes?
Okay.
The first line.
Yes.
And then there's a number of entries. They go all the way down to number 15. And all those entries are for the year 2013. Is that correct?
Okay.
Strictly
we are talking about new classroom expenses.
Well, I don't know what I'm talking about yet. I'm just about to ask you some questions.
Mr. Lovett, one of them is 2014.
Yes, my lord, I was coming to that. So item number 14 seems to be it sticks out as 2014, but the others I think are 2013.
Mm-hmm.
So, Mr. Rashad, these entries, and you can see the description in the line here and the line items.
Okay.
You can read them to yourself. I don't particularly want to read them out. I will do if you want me to, but total cost for transformers, metal doors, engineering office. There's some transformer equipment. There's electrical schemes, there's cables. So there's a lot of entries here which have a book value, which is then the next column along. Do you see that?
Yes.
Now, I'm going to suggest to you that all those entries up until 2017, they all relate to old buildings that have been demolished.
No, it's new building.
How can you be so sure?
1 second, please. It's I think starting from 2017, 28 February 2017, this is a new building contracting with this is a new building after we demolish the old one.
Correct. So that's what I'm saying to you. I'm saying to you that these buildings have been demolished. The dates that relate to 2013 and 2014, these are buildings that are old buildings. Would you agree with me?
No, I think they start in 2017 for the new building.
Mr. Rashad, if you look at the entries from 1 to number 15, you've just agreed with me, apart from one entry, which the judge told me was 2014. You agreed with me that all these entries were for 2013. That's correct, isn't it?
It's related to the old building, not for the new constructions.
Correct. And those old buildings were demolished. When were they demolished?
Not all demolished. I explained to you this amount in the beginning. It's related to the yellow building plus some small classroom. They already established some new classroom. Like in 2014, this new classroom expenses. It's new classroom. It's not the old. It's not the old classroom. It's the new classroom in the school campus.
And can you identify those classrooms?
It's already mentioned here. It's classroom.
Where does it say classroom?
See, you can see here the new classroom expenses. It's very clear.
Yeah.
Number 14 and 15 new classroom expenses.
Correct. What about the other entries? They're the only two that relate to new classrooms.
You mean before 2017 or after 2017, please?
Before. So 2017 is the new classrooms. I understand that.
Yeah.
I'm talking about the entries that lead up to 2017, and I'm trying to understand from you what these relate to. Your evidence appears to be that some of those costs, the top line, is for the ICS or the yellow building, but you tell me that some of these entries are undertaken by other members of your staff, and I don't quite understand from your answers exactly which buildings these entries relate to. And I'm hoping that you can help me.
As explained to you, we have some very old classroom. It's related to Ministry of Educations. We already removed it. It was 0 in our books because it's already rental old school related to Ministry of Education. That's why it was allocated as a value inside our books. The value what we added in the books only the building what we built by ourselves.
Okay. So all I'm sorry to take time, but I just want to make sure I understand your answer. Are you telling me that these up until 2017, all of these buildings, all of these entries were reflected at a 0 value in your books? Is that correct?
I'm not saying all these expenses is the 0 value in our books.
But what
I
you
mean the old building related to Ministry of Education. We are rented from Ministry of Education. It was since 25 years. It's 0 in our books.
Yeah, I understand that.
We are allocate only the new classroom or new expenses by ourselves. Because the building, it was rental from Ministry of Education. It was government school, but we rent from the government school, not as the old owner from AJIAL.
I understand that, Mr. Rashad, but by definition, if you're saying the old MOE schools predated 2017, because you've told me 2017, you started building new classrooms, correct?
New building, not new class.
New building.
Yes.
So everything before 2017 was MOE? Is that what you're telling me?
Also, the new building is related to Ministry of Education. I need you to understand this place, all this place, 50,000 square meters, is related to Ministry of Education. It's rental building for Ministry of Education.
I'm interested in the old buildings, Mr. Rashad, not the new ones.
Also, the new one. Sorry. Also, the new one. Once I built, I can register as assets in my books, but he is rental for ministry. I built, for example, 100 classroom by myself. I can record as assets inside the books, but I have to pay the rents to Ministry of Education.
Can we just turn to a new document, please? Number 2579.
Mr. Lovett, I know you haven't finished. It's after 3 o'clock now. Sorry, after, yes, 3 o'clock, after 6 o'clock your time. How long
I may just have a few more minutes, my lord. I thought I might finish before the adjournment, but I may have a few more minutes. But I'm happy to finish now because it's a new subject within the accounting evidence, but it's a new topic. So I'm happy to finish here.
I think we should stop here. Mr. Rashad, can you be here tomorrow morning?
Yes, sir.
Thank you. Then we'll stop now. Can I ask you not to talk about the case in the meantime, Mr. Rashad? Don't talk to anyone about the case. You understand? Mr. Rashad?
Yes.
You understand you mustn't talk to anyone about the case before tomorrow morning.
Okay, sir. Okay.
And we'll resume at 12 o'clock tomorrow morning, Dubai time, 9 o'clock UK time. Thank you very much.
Thank you, my lord.
Thank you.